May I please, Lord?
Yes,
Item number 41, my lord.
41.
Yes, my lord.
Huh?
It's coming to in orders, my lord. I have prayed last time to file an affidavit in this case, my lord.
Huh?
My affidavit is still not has come from the client side, my lord, for signatures. My lord will grant me some time to file that affidavit, my lord. I have seeked the consent from the other side, my lord. Amicus query I have already intimated, my lord.
Intimated, na?
Yes, my lord.
At the request of the learned counsel appearing for the appellant. This matter again on?
My lord, 10 days time may be given.
On the 4th of May, allowing him to file
Affidavit.
the affidavit. Yes.
Item number 10, Lordship.
10.
Yes, sir.
Huh?
Criminal revision.
Yes.
I have some personal difficulties, Lordship. I
At the
have
request of the learned counsel for the petitioner, release this matter again on?
after 3 weeks. Lordship.
Give us a date.
First week of May, Lordship.
8th of May.
Yes, please, Lordship. Lordship, with the due consent of the other side, I beg to mention item number 42 and my lord 59 of today's
42
and 59 and 59. Lordship, I am appearing in as an amicus here, my lord. I am actually, my lord, I have some personal difficulty today, my lord. Can this matter be taken up, my lord, on the first week of May, my lord? Any date, my lord?
At the request of the learned amicus in the matter, list this matter again on
First week of May, my lord.
8th of May. 8th of May.
8th of May.
দুটা আইটেম বেলেগ বেলেগকে লিখিব।
May I please?
Thank you.
Yes.
I beg to mention item number 3 of today's list.
E.
3.
Yes.
Last occasion report from the Bagbar police, but till now report is not called.
Huh.
So,
Let the matter reach with the item 3. What is the hurry in mentioning the matter at item number 3?
and I beg to mention also item number 30 also.
Do that. 30 years.
30.
When do you want it?
CD is not coming.
CD has not come. Item 30. Heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP who has submitted that the CD is to be received. List this matter again on
First week matter.
6th of June.
I mean
6th of May.
6th of May.
Interim.
Awaiting the CD. Stop. The interim order passed earlier continues.
Awesome. May I please, your lordship? I beg to mention item number 18, lordship.
1818.
18, lordship. Case diary has not been received, lordship. Can it be listed on 7th of May, lordship?
Mr. So-and-so appears for the petitioner. Learned APP has submitted that the case diary is awaited. List the matter again on
7th of May.
7th of May, awaiting the CD. Interim order passed earlier shall continue.
Deeply obliged.
Yes, sir.
Lordship, in item number 6,
Six.
an affidavit has been filed by the petitioner, which may kindly be called for, Lordship. It's not the end of it.
Slip on Lulu.
Yeah, please.
Yes.
I beg to mention item number 19. of the daily list.
Yes.
But CD not issued. Yes. I am on interim.
Mr. So-and-so appears for the petitioner. Learned APP has submitted that the CD is awaited. List the matter again on.
Second week matter. Any
Then we'll have it on 11th. 11th of May.
Interim.
2026. Interim order passed earlier shall continue.
Lordship. Deeply obliged.
My pleasure, Lordship. Lordship, I beg to mention item number 56, 57, and 58, Lordship. Hearing matter, Lordship. Consent of the other side has been taken, Lordship. Actually, engaged counsel is out of station. He is suffering from some eye infection, Lordship.
I appear
At the request of the learned counsel for the petitioner.
Lordship, respondent,
For the respondents.
Yes.
With the consent of the learned counsel for the petitioners. List this matter again on
Lordship, 28,
28th.
28, Lordship.
28th of April 2026.
based on interim order.
The interim order passed earlier continues.
Obliged.
Don't you kindly pass over to item number 32 and 33?
32 and 33. Why we have got the CD, why not do it?
32 and 33 we have CD matter. CD
This 32, 33 CD is there. Why don't you take a chance? Not confident. Your name?
SR Das.
Miss Asadas appears for the petition and prays for an accommodation for the day. Learned APP has submitted that the CD is
available.
CD has been received. When do you want it?
Lordship.
When do you want it?
Lordship, any date.
Any day, tomorrow.
Actually, after 1 week.
After 1 week. 34 is also connected. Have you taken the consent of that person? No.
34 is not our.
It may not be yours, but it is connected. Same.
Yes, Lordship.
You wait, let person in 34 come. We'll pass over your matter for the day.
Okay.
We'll have it next week, but let the other person appear.
Lordship, and
Since they are tagged.
interim orders in item number 32 may be continued.
We'll do it when the matter reaches.
Okay, Lordship.
Wait for it. Yes, Mr. Dedi?
Your Lordship, I'm mentioning item number 11. I'm
11.
by Kane Chaudhary in this case, Your Lordship. And I'm praying that the matter will be adjourned for the day and the same will fix next week. Any date next
At
week.
the request of Mr. P. Dedi, learned counsel for the petitioner, list this matter again on 29th would be,
Yes, sir.
29th of April 2026.
May I please, Your Lordship?
Yes.
With the consent of the other side, I beg to mention item number 13. That's
1-3.
1-3. May it kindly be adjourned for the day, my lord.
At the request of the learned counsel for the petitioner, with the consent of the learned counsel for the respondents, list this matter again on
My lord, preferably on 12th of May.
12th of May.
Very grateful, Your Lordship.
Please.
May I please, Your Lordship? In item number 29,
Hmm?
I beg to mention that kindly pass over the matter for the day.
Your name?
29 my lord, CD not received my.
Huh?
Didas.
Miss, at the request of Mr. Didas, learned counsel appearing for the learned counsel for the petitioner. List this matter again on
And-
First week, my lord, any day.
first, on 6th of May.
6th of May, my lord.
Learned APP shall ensure the receipt of the CD by that date. Yes.
Here, item 1.
Item number 23.
29.
No, 20.
Well, it is an application of 493.
Hmm.
483.
Hmm.
100 days behind the bar after charge sheet, my lord.
Hmm.
And my lord, though FIR I am in the name, there are 4 persons. Others were
Apuni no ni kya?
not charge sheeted, only me was charge sheeted. Well, but evidence will go, see that if I have annexed the evidence also, he said that there was a regular derogatory comment against my sister, for which I was provoked and I attacked. He admitted. And my lord, thereafter, it is every witness said that it is a long-standing dispute of land between the two families. So, my lord, I am a local boy of that Sribhumi. So, my lord, 100 days behind the bar, enough punishment. Rest of the, if I convict, I'll be in jail. Kindly give me some protection for bail.
Mr. Busho,
My lord.
what do you say?
And 36 has not been complied with. 36. There is no respectable witness.
My lord, here, my lord, only the part is that, my lord, because of earlier gas, carrying Dow Lathi attacked with the Dow assaulted him head and 6.
He admitted in his evidence that because of the provocation, I have attacked him with dao. And there
And my
are
lord, as a result, my son became unconscious on the place of occurrence.
he recovered not long ago. He was in the hospital.
Where is the statement saying that there was something about the sister?
I'm showing 42 page.
Page 42.
42.
Who has admitted that?
Accused statement, page 42. My particulars is true. They stated about I am admitted that on 9/1/25 I attacked Misbahul Islam. He always passed derogatory comments on my sister. For that reason, I attacked him by using sharp dao. And thereafter I fled away. And moreover, my other witnesses that there is a long-standing dispute between two families.
Where did you strike him, on the shoulder or on the head?
No. It is not a vital part.
Yes, charge sheet has been submitted.
Yes, my lord. Can TCR may be called for, my lord, at this stage, my lord.
But what is the use of? I am facing the trial. Next day it is for framing of the charge also. I will face the trial under any condition. The question is that I have to cooperate with the trial. That is, it is not the case that I must be behind the bar. There are cases, my lord, after charge sheet also, your lordship can consider the bail. There are so many cases. Even a CBI cases also after charge sheet bail has been granted.
Where is the 36 part?
Beg your pardon.
36?
36
Notice.
page number.
Ah,
36, your lord will find that my particular truth that
yes, where is that signature of the witness? Arresting witness, nothing. And it's a personal fight. Does not appear to be instigated by anything else. Huh? Heard Mr. S.C. Biswas, learned counsel, appearing for the petitioner. Also heard Mr. Bushra, learned counsel, learned APP, appearing in the matter. This is a bail petition under section 483 of the BNSS 2023 for granting the regular bail to the accused who was arrested on 12/1/2026 in connection with Ramakrishna Nagar PS case number 01 of 2026, which has culminated in sessions case number 35 of 2026 under section 126 within bracket 2/118 within bracket 2/109 within bracket 1 of the BNS, pending in the Honorable Court of the Session Judge Sri Bhumi. The learned counsel for the petitioner has submitted that at the time of the arrest memo which was prepared did not contain the signature of any independent witness, and therefore there is a violation of the law. And in such circumstances, it is settled law that the petitioner would be entitled to the privilege of bail, since the custody after an illegal arrest is deemed unconstitutional. Full stop. The learned counsel for the petitioner has also submitted that the occurrence of the incident is not disputed by the petitioner, even in his statement recorded before the police authorities, and the reasons for such incident has also been explained. Full stop. The learned counsel for the petitioner has submitted that the petitioner is a permanent resident of the same area and he is willing to face the trial, and there is little or no chance of his absconding or avoiding trial. Full stop. Under the circumstances, he has prayed for grant of regular bail during the period of trial. The learned APP has submitted that in view of the submissions made, the petitioner appears to have committed the offense of causing a grievous hurt upon the victim, and therefore he would not be entitled to the grant of bail at this stage of the trial. Full stop. Charges have been framed.
No, not yet. It will frame it.
At this stage of the trial, when charges are not yet framed. Full stop. This next paragraph. This court has gone through the notice under section 36, the arrest memo under section 36 of the BNSS, and finds that it does not contain the signature of any independent witness at the time of the arrest of the petitioner. Full stop. Further, therefore, this court is of the opinion that the petitioner is entitled to the privilege of a regular bail in the matter during the period of trial. Accordingly, it is directed that the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with two sureties of the like amount to the satisfaction of the learned session judge Sri Bhumi, in connection with sessions case number 35 of 2026. Full stop. The learned session judge shall be at liberty to impose such other conditions as may be necessary to ensure the participation of the petitioner at the trial. Bail application disposed of. Please. Yes.
Sorry, in item number 39, I have taken the 29. 40
In item number 39, you have taken 29.
With 39.
Let her explain. She has to explain. Yes. What have you done?
Mistakenly, I have told 29 in place of 39
Okay.
for the urgent item.
29 G2 order লিখিছিলে strike out কৰি দিব item 39 কৰি দিব হা okay
What is the regular bail application, my lord? Lordship will find FIR.
just a minute আগৰ অৰ্ডাৰটো লিখি দিব learned APP has APP has submitted that the scanned copy of the TCR may be called for. However, this court is of the opinion that when the notice under section 36 is in issued, I'm calling for a scanned copy at this stage is not required. Yeah.
FIR is at page number 9, my lord.
Page number 9.
Page number 9.
Huh?
The allegation here is that the deceased and the accused, my lord, are husband and wife. There has been long-standing dispute between family dispute, my lord. But actually on 23rd or 23 to 2025, this was the mentioned alleged incident, date of incident, my lord. On
Call
that
for
day,
the
my lord-
CD.
Yes, my lord. And
Person has died. Someone
yes,
has.
yes, my lord, yes, died. My lord, the medical opinion is to be required, my lord, medical. Because they have said the date of incident is on 23 to 2025 at around 1 a.m. But it is actually not the date of incident. On 24th, my lord, it is somewhere between 9 to 11.
Medical
Medical
opinion.
opinion
Learned counsel appearing for the petitioner also heard the learned APP, Mr. K. Bhushan, learned APP appears for the state. This is a petition under section 483 of the BNSS 2023. Paying for regular bail in connection with Kokrajhar PS case number 33 of 2026, where the petitioner was arrested on 27 to 2026 full stop. Call for the case diary, list again on.
27.
Huh?
But 27 might not be difficult, my lord. First week, my lord.
Give us a date.
My lord.
4th of May.
My lord. Yes.
4th of May.
4th of
2026. The learned APP shall also call for the medical opinion, since there is a dispute regarding the date of incidents.
city along the PM.
Obligation.
Item 3.
Yes.
Last of the report was called for from the Bagbar police station. Any FIR is lost or not, but
Oh yes, what happened to it?
My lord, yet not received, my lord. That is awaited, my lord. So we pray for a short accommodation, my lord.
The learned APP has prayed for a short date to have his instructions as required by the order dated 23/2026. Accordingly, list this matter again on the 7th of May,
6th of May.
6th of May 2026.
Interim still.
The interim protection granted earlier continues.
Of life.
Yes, sir.
FIR is at page 12, my lord.
Page 12.
Page 12, my lord. Particular, my lord.
Huh?
So we'll find that, but this incident took place because of parking of a car, my lord, in the market area, my lord. Because the son-in-law of the informant, he parked the car. The shopkeeper opposed it, my lord. He did not listen. That led to a quarrel, my lord. On the spur of the moment, a quarrel took place because supporters of the shopkeeper, they came and this is a quarrel took place, my lord. And, already 8 persons have been released on bail, my lord. And this person, but there is an allegation against him, my lord, that he took a dough from the nearby shop and then he hit him on the head of the son of the, my lord, informant. But the only thing is that though he has been injured, my lord, this my humble submission is that he is simple injury, my lord, because he has not been taken to hospital even, my lord. There is no mention that he has been taken to hospital. Anybody, any injured person nobody has been taken to hospital, my lord. Although 109 is there, but it is not applicable in this case, my lord.
No, I don't know.
Only on the spur of the moment, my lord, it took place, my lord, in the market itself, my lord. And there is no mention that he has been taken to hospital to refer to some higher.
How old is this person, this petitioner?
Petitioner is, my lord, 43 actually. 43 years, my lord. 43 years, my lord.
Yes.
My lord, here, my lord, accusation is against, my lord, the petitioner number 1, my lord.
Yes.
That is, my lord, as a result, the accused number 1, that is the present petitioner, my lord.
Yes, ma'am.
With a dough hit him on his head, causing grievous injury. So now, my lord, pre-arrest bail application, my lord. So, my lord, let the CD maybe come.
But that is allegation, my lord.
Let the CD come along with his statement. Why did he?
Yes, my lord.
Yes, my lord. Yes, my lord.
But Mr. Mukhtar, learned counsel appearing for the petitioner, also heard Mr. Bushel, learned counsel, learned APP for the state. This is an application under section 482 of the BNSS for granting pre-arrest bail to the petitioner in connection with Dhing PS case number 63 of 2026.
My lord.
Full stop. The learned counsel for the petitioner has submitted that other co-accused in the matter have been granted the privilege of an interim pre-arrest bail, allowing them to appear before the IO to participate in the investigation. Full stop. The learned counsel for the petitioner has submitted that given an opportunity, the petitioner would also appear before the before the investigating officer and cooperate with the investigation. Learned APP has submitted that the allegations in the FIR are directly against the petitioner hearing and not against the other co-accused, and therefore the petitioner may not be granted the privilege of an pre-arrest bail. On going through the materials, this court is of the opinion that the petitioner is required to appear before the investigating officer to participate in the investigation. Accordingly, the petitioner shall appear before the investigating officer on or before
7
The-
days, my lord.
huh?
Within 7 days, my lord.
on or before the 29th of
My lord.
April 2026 to have this statement recorded. Till such time, it is provided that the petitioner, if arrested, shall be released on bail on furnishing a bond of rupees
20,000.
25,000
My lord.
with one surety of the like
My lord.
amount. Subject to the following conditions. Page 18 of condition kita agor bill to dia ase. Kita di dibo. The case diary be produced on the next date of listing for further consideration. List the matter again on 8th of May.
8 of them.
Obliged.
The one-time settlement talks are going on between the parties regarding the amount. So time may be granted.
Learned counsel for the petitioner has submitted that there is some scope of a settlement between the parties, and therefore the matter may be listed after 4 weeks. Accordingly, list this matter again on 29th of May 2026, allowing the parties to go for a out of court settlement.
Item 6 and 7.
Yes. এইটো আছে নেকি ভিচিট আছে নেকি? Yes. Death certificate report. After some time. After some time.
Lordship, we can take up item 6. It doesn't need that death
Do
report.
we need to take it up in a?
Lordship, I have a,
All right. Item 6.
this death report case, Lordship, can be taken tomorrow also, Lordship.
Item 6, not tomorrow. We'll do whatever we have to do today if possible. Yes.
Lordship, I am the respondent number 2 in item 6, criminal petition
Who is the
558
petitioner?
of 24.
Item number 6 is. Ito kiman number dito? 7 number dito. 6 number dito. 6 number dito. Criminal petition funding. Criminal petition 558. Ekona side to you. The order was passed for the death certificate in item number 6.
Lordship, that is in item number 7, Lordship.
Anyway, yes. Yes. Has he joined on VC? So VC joined anything? You are with Mr. Sonar?
No, Mr. Postmortem.
No, you are with Mr. Sonar. He's yes. Yes, Mr. Sonar, tell us.
My lord. My lord, my lord, as per the direction of this honorable court, my lord, I filed the affidavit, my lord. Explaining, my lord, my lord, I will just take out my file. My lord.
এখানে আহিছে নেকি এফিডেভিট খন? এফিডেভিট এখন কল ফৰ কৰা গৈছিল আহিছে নেকি? আহিবহি নাই? Affidavit is yet
Sir,
to
we
come.
can have it at 2, Lordship.
We'll try. At 2. We'll have it at 2, Mr. Sonar,
My lord, my lord,
along with the affidavit.
my lord.
All right. Yes, next.
Lordship.
8 and 9.
Lordship, in respect of item number 8, Lordship, on the last occasion, so I just prayed that for filing the affidavit in reply, Lordship. I prepared, Lordship. Today itself, I filed, Lordship.
Okay.
That is not in record. We have not received a copy.
He will file it today. You are Mr. Burman.
Yes, Lordship.
The Mr. Burman, learned counsel appearing for the respondent, has submitted that the affidavit proposed to be filed on behalf of the respondent has been prepared and will be filed during the course of the day.
Today.
Huh?
Today itself.
During the course of the day, allowing Mr. Burman to allowing the learned counsel for the respondent to file the affidavit. List this matter again on when 27th, or would you? Yes, 27th of April. He'll file the affidavit today. Interim order passed earlier continues.
Yes.
Both 8 and 9.
9 to 9.
What is 9? Item number 9.
Appearing for in the 9, item number 9, my lord.
Who's the petitioner in 9? Who is for the petitioner in item number 9?
Same petitioner, Lordship.
Eh?
Same petitioner, Lordship.
8 is the, my lord, criminal revision. And two cases. One is against the domestic violence case, and another is against the 125 matter, my lord. So in both cases, the husband is the petitioners, my lord.
So both 8 and 9 will take it about 27th.
My lord, may I pray it other than 27, my lord? I might go to 28 if possible.
Choose a date. Huh?
28.
28?
Lordship, 25 problem.
29?
29 can be done.
Discuss a date and tell the court.
29.
Discuss a date and tell the court.
29.
29?
He is also agreeing.
29th. 29th will do.
My lord, item number 9, there is an interim order.
The interim order in item number 9 continues. Item number 9 to Haley Kitty for criminal revision number so and so continues.
Deeply obliged, Lordship.
Yes, item 12.
Item 12.
I'm for the AG, Lordship.
You are for the AG. Yes, sir. Kindly inform is that heard? Heard. Clear.
15.
Lordship, kindly pass over the time being, my lord. Sorry. Pikero Chaudhary's legs in another court.
Hearing beer, item 16.
Mr. So-and-so, please. Yes.
My lord, CD not received, my lord.
What is the case about?
Lordship,
What is the case about?
under 75,
Huh?
75 flows 164 and 351 of BNS.
Is that how you prepare a bail petition?
Lordship?
Is that how you prepare a bail petition?
Yes.
You are telling me section so and so, section so and so. That is how you argue a bail petition.
Lordship.
Huh?
Lordship.
Yes, why is the CD not coming?
My lord, they pray for a sort of accommodation, my
Huh?
lord. A sort accommodation, my lord.
Have you seen page 20?
No. Right. Short date, my lord.
You've seen page 20? Arrest memo under section 36 of the BNSS?
Yes.
Huh? Item number 1. And he's behind bars. And we will await the CD. Till when? Give us a fixed date.
Short date, my lord.
Mr. So-and-so appears for the petitioner. Learned APP has sought for a short accommodation to produce the CD. List again on 29th? 29th of May, April 2026. Awaiting the CD. Please ensure the CD then.
Yes, ma'am.
My lord, my lord, 17, my lord, Mr. H is on the way only. He's having the breed, my lord. Can be after some time. I've informed him, my lord. Case diary is already there, my lord.
Case diary is come.
Yes. I've informed him he's coming, my lord. Five minutes, my lord. I've informed him.
Where do they get these ideas from?
No, my lord. Actually, he's like in court number 3, my lord.
No. The accusations in the FIR, if true,
My lord. Yes.
where do these people get this idea to do those things?
Yes. That is true, my lord.
Ingenious ideas.
Yes.
Yes. Item 81, 18. 20. Yes, Mr. Saikia.
Yes.
Item 20.
My lord, item number 20 and my lord 21. Both my lord matter may kindly be time being, my lord. Mr. Midhupapan Goswami, my lord. Colleague. He has gone through that.
He has
He's
gone
on
to the
late.
record. After some time?
After some.
What was the allegation, Mr. Bushu? Any idea?
22, my lord. Still do it. 22 also, my lord, matter may kindly be time being, my lord. All these 3 matters. No. 22.
May I please, your lordship? Pre-arrest bail application, lordship.
22, no? 22 ne ki? Well, 22 also matter may kindly be time being, my lord. So if Sami has gone through, my lord, that.
Okay.
We will take time. Anyone will appear.
Let Mr. Goswami be here.
My lord. এই গোটেইকেইটা কৰি দিছো এইকেইটা হেৰি
Lordship, updated CD was called for 23. And the petitioner had recorded their statement. Lordship, please.
My lord, updated CD not received, my lord. 23, my lord.
So as per my information, they recorded their statement, Lordship.
Yes.
The petitioner has recorded their statement before the IO, Lordship. And Lordship, one accused has already been granted bail, Lordship, anticipatory bail. That is accused number 6, page 12.
You are on interim.
Yes.
Let us have your statements.
My lord.
Huh?
Updated CD, my lord.
The Ms. T. Shoharial and counsel for the petitioner has submitted that one of the co-accused has already been granted an anticipatory bail in the matter. Anticipatory bail in connection with the same FIR. Full stop. Mr. Gauhati and APP has submitted that the updated CD is awaited. List the matter again on. When? When? Mr. Gauhati, when?
But 12th, my lord.
12th of May.
12th of May. my lord.
Interim order, interim protection granted to the petitioner's hearing continues till that.
Supplementary for this item 62.
This is second bail petition.
We had asked yesterday something. Yes.
Malad, yes, here Malad, up to out of 7 witness Malad, 4 examined till 24/3/26. Sashit was on Malad forwarded on 5/10, subsequently Sashit and till 24th of March, 4 examined. 1 and 2, I have flag mark, kindly see. 1 and 2, those are seizure witness, they stated that when police searching in a room, particular room, they have not found anything.
They have not seen the seizure.
Yes, but another team searching in the subsequent room, innocent room, those you are sitting, accused are sitting and consider the voter will find it. Now, my submission is that 3 witness more remaining more. Let the other witness be examined because speedily is going on. There is
We
no
understand. Speedy trial is going on, is understand, but when the what is the strongest, what is the weakest link? The seizure. It is the strongest and the weakest link, is it not? Link goes.
both the seizure witness. Otherwise, they specifically stated that the other team searching in the adjacent room immediately called them. They went to that room and they found that he is sitting, accused is sitting in the floor.
Surrounded by all the bottles.
All over.
Now, to surround him with the bottles would have taken some time. So it could not be immediate. Huh? When were you arrested?
5/10, 25.
5/10/2025.
6 months, 16 days.
Gauripur. Where is the trial going on? Gauripur.
Yes.
Gauri itself. But Mr.
My lord.
You are not there in the Wakalatama?
Yes.
You are there?
Yes.
But Mr. Swenson and a counsel.
Ke Kulita.
Huh?
Ke Kulita.
We heard Mr. K. Kulitala and a counsel appearing for the petitioner. Also heard the learned APT, Mr. Parashar. Stop. This is a petition being for regular bail under section 483 of the BNSS 2023 for granting bail to the petitioner in connection with special case number 260 of 2025 pending in the court of the learned special judge Dhubri. Full stop. The petitioner was arrested on 5/10/2025. Full stop. After this, the learned counsel for the petitioner has submitted that the trial is proceeding before the learned trial court, and up to now, 4 witnesses. How many witnesses examined? 4. 4 witnesses have been examined. Full stop. The learned counsel for the petitioner has submitted that the petitioner has been cooperating in the trial, and the statement of the witnesses would not be enough to implicate the petitioner with the alleged offense. Full stop. The learned APP has submitted that already 4 of the 7 witnesses, 7 proposed witnesses.
Out of 7.
4 out of the 7 proposed witnesses have already been examined, and at this stage, the petitioner may not be granted the privilege of a bail since the trial is proceeding at the right base. Full stop. On an earlier occasion, this court had granted liberty to the petitioner to approach the trial court to pay for regular bail, and it has been submitted that the bail petition referred by the petitioner has been. Did you approach
Yes,
after we gave you the liberty?
yes, yes. Page number 58.
And given, the petitioner had been given the liberty to approach the learned trial court, and upon approach to the learned trial court, the bail petition of the petitioner had been rejected, since only 2 witnesses had been examined by the prosecution and 5 remained to be examined. Full stop. Having gone through the scanned copy of the TCR, this court is of the opinion that the petitioner can be granted the privilege of a bail at this stage, since 4 witnesses have already been examined and 2 of them, the Seizure witnesses, have also been already examined and cross-examined. In such event, this court directs that the petitioner be released on bail on furnishing a bond of rupees 30,000 with 2 sureties of the like amount, one of whom shall be a government servant, to the satisfaction of the learned trial court. Instead, the learned trial court shall also be at liberty to impose such other conditions as may be deemed necessary to ensure the participation of the petitioner in the remaining of the trial. The bail application is accordingly disposed. We have given 2 sureties, 30,000, one of them a government servant, and other conditions to be imposed by the trial court. Is there any
CD did not receive, my lord.
Mr. So-and-so, your name?
I am Rahman.
What is the matter?
Matter is, my lord, under section 69, my lord. Allegation was from a lady, my lord, that I had a relationship with her, my lord, and apparently, my lord, thereafter, that.
So
it
have
was
you,
lost.
have you
My lord,
recorded your statement?
Yes, my lord.
Have you appeared before the investigating authority?
Yes, yes, my lord. I went there.
Your name?
M. Rahman.
Mr. M. Rahman, learned counsel for the petitioner, has submitted that the petitioner is appeared before the learned, before the investigating authority, and his statement has been recorded. Learned APP prays for some time to produce the updated CD. Accordingly, lists this matter again on the 11th of May.
11th of May.
Along with the
Actually, my
updated
last 4 occasions, my lord, last 4 occasions, my lord, that could not produce case diary, my lord. So my humble prayer, my lord, make it happen. Absolute, my lord.
On the next date.
My lord.
25.
God bless you.
Up to date CD was called for lodging. And I have appeared before the learned trial, before the IO, and my statement has been recorded.
CD not received, my
Mr.
lord.
So-and-so learned counsel appears for the petitioner. The learned APP has sought for a short accommodation to produce the updated case diary. Learned counsel for the petitioner submits that the petitioner has appeared before the investigating authority and his statement has been recorded. Place this matter again on the 8th of May.
8th of May.
Interim order.
Awaiting the updated CD, interim order continues. Agora to interim order continues, devotee.
Obliged.
26.
Which CD was called for?
That is, my lord, CD not received, my lord. Interim is there.
What is the matter about? What is the allegation?
Allegation was trespassing in the house.
Heard Mr. So-and-so learned counsel appearing for the petitioner. The learned APP has submitted that the updated CD is awaited. List the matter again on 11th of May.
11th of May, my lord.
2026. The updated CD, interim protection granted earlier continues.
27.
May I please mention? Case diary was called for, nothing. Lordship, initially there is no FIR when we file this case.
27.
There is a apprehension of arrest. So, as because the Nunmati police station repeatedly called the petition. Thereafter, we searched that there is no any FIR. So we preferred this bail application before your Lordship. Thereafter, on 13/3, instruction was received that a case was registered. So learned coordinate bench, honorable coordinate bench called for the case diary. And we have filed an additional affidavit, Lordship, annex the FIR. In our additional affidavit, page 15, Lordship, 17, vernacular, Lordship, FIR. There is a misappropriation of fund, Lordship. And on 13/3, when instruction was received, it was verbally submitted by the learned PP that police has conducted a preliminary inquiry. The petitioner was called by the police on February 10, Lordship. But information was received on 10 March, Lordship, after 1 month. But initially, we have stated categorically stated in our petition that petitioner was called by the police on February 10, Lordship. She was in police station. And thereafter, police repeatedly visit her. So when there is no any case, so we have filed this bail application. And after when the instruction was obtained on 10/3, on 10/3, police registered the FIR. Let's say there is a after
CD not here.
My lord, this matter, my lord, Sarset submitted, my lord.
Huh?
Sarset submitted, my lord.
So,
petitioner may be protected, Lordship, till appearance, Lordship.
heard you are Mr. D. Chutia.
D. Sutia.
Heard Mr. D. Chutia, learned counsel appearing for the petitioner, also heard the learned APP, Mr. Bush.
My lord.
The learned APP has submitted that the charge sheet bearing CS number.
PS number 38/26, dated 33/2026.
Has been submitted in connection with Nunmati PS case number.
Nunmati PS case number 41/2026.
41 of 2026. Full stop. The learned counsel for the petitioner has submitted that since the charge sheet has been submitted, there is an apprehension that the petitioner may be arrested prior to may be arrested. Stop. The learned APP has submitted that there is no question of arresting the petitioner now by the investigating authority since the charge sheet has already been submitted.
My lord.
Accordingly, this anticipatory bail petition is closed by observing that by directing the petitioner to appear before the learned trial court as and when he receives summons from the same. The submission of the learned APP that the question of arresting by the investigating authority after submission of charge sheet does not arise is also taken into account. When appear when you get the
Yes, obliged summons.
Pursuant to interim order, my lord, I appeared before IOM. Statement is recorded, and my lord, the co-accused who is in absolute bail, my lord. My lord, the case is that, in fact, my lord, I have been falsely implicated by the informant. Informant who is the main accused in this case, my lord.
informant is the main accused.
Informant has committed the main offense, my lord. But to cover up that, my lord, that FIR is filed, which is, my lord, I have duly, my lord, mentioned in my petition, my lord.
You are on interim.
I am in interim.
The heard Mr. So-and-so on counsel appearing for the petitioner. The counsel has submitted that the petitioner has appeared before the investigating authority after the protection was granted to him by this court during the pendency of this petition. Learned APP has
CD
sought
not
for
received,
some
my lord.
time to produce the updated CD. List the matter again on the 11th of May.
11th of May.
11th of May, awaiting the updated CD. Interim order passed earlier continues.
My lord.
Wait, please, your lordship. Your lordship, CD was called for today.
It is special PP vigilance.
Huh? Have you appeared
Yes, sir.
before the IO?
Yes, yes, your lordship.
You have appeared?
Yes.
Your name is?
Yes, Rahman.
Yes, Rahman, learned counsel appearing for the petitioner. Learned EPP has submitted that the Updated case diary is awaited. That the updated case diary is awaited. The learned counsel for the petitioner has submitted that he has appeared before the investigating officer during the pendency of this case. Full stop. This is matter again on the 13th of May.
13th of May.
Awaiting the CD.
My lord.
Interim order passed earlier continues.
I'm sorry, Mala, I was not there when you first called.
No difficulty.
Mala, it's a regular bail application under 482 of the VNS, minor SS, minor. Here the accused petitioners are in custody for around 3 and 41 days respectively, my lord.
My lord, this matter, Mr. Goswami has gone through, my lord. He is on legs in, my lord, another. So for time being, my lord, all these three matters. My lord.
After some.
After some.
31.
May I please, Your Lordship?
Yes.
Lordship, nothing left in this case. I appeared, statement recorded, Lordship. So matter may be directed to be absolute, Lordship. This is my humble prayer. A small case, one calf was stolen, recovered. Main accused person is also arrested. I was co-accused, and my name was listed as co-accused. I appeared, statement recorded, Lordship.
And calf also recovered.
Recover. Main accused person has also been.
You helped him carry the calf.
No, Lordship.
What was your role?
My role, nothing. Only a vague statement made by the main accused.
Here we have received the CD, but whether he appeared or not, that is not reflected in the CD because CD is not up to date, madam. So I pray for up to date CD, madam. He was granted interim on 31/3.
When will you have it?
My lord, this is from Bongaigaon. It will take,
27th?
my lord, after that, my lord, it will take time.
30?
30, my lord.
30 April?
30 April.
30th of
April.
Interim may continue. Oblige, deeply.
Mr. D. Gogol and a counsel appearing for the petitioner also, learned APP has submitted that the updated case diary is awaited. Mr. Gogol submits that that the petitioner has appeared before the investigating officer. And in fact, the stolen calf has also been recovered. This is matter again on the 30th of April, allowing the learned APP to
CD may be
produce the
returned,
updated case diary. Interim order continues.
Hey, please, Your Lordship. Lordship, pre-arrest bail application, Lordship. Lordship will find the FIR on page 13, Lordship. Lordship,
Oh, yes, this is for the wife.
Wife. Matlab the husband siphoned the amount from the company and transferred to the bank account of wife, son, daughter,
Not son, daughter.
father. Wife she has appeared. She stated that I don't know about this and my bank account, everything in the hand of husband.
From ages, wives have been taken to be innocent to the actions of the husband. Is it not?
Otherwise,
She
she has appeared, she has cooperated.
He's appearing for?
No.
Are you appearing in the matter, sir? Yes, you are appearing for whom?
Informant.
Informant. What do you have to say?
Money is in mutual fund, so if given granted bail, it may be liquidated.
Who? She's already on interim bail.
Now, what he's saying is that on last.
He's already on interim bail. Whatever had to be made liquid has been made liquid by now. She's the wife.
Main culprit is the husband.
Get an order for seizure of the bank accounts and everything.
Lordship, already those are seized, Lordship. Already freezed. All accounts are freezed.
Heard Mr. D. Middle counsel appearing for the petitioner, also heard Mr. APP appearing for the state. The case diary has been received. The petitioner was on interim bail by the order dated 27/11/2025. Full stop. The petitioner is the housewife of the main accused in the matter where allegations have been raised that the husband of the petitioner had siphoned off some money from the accounts of you are a what? What was it? From
the
From the,
director of TNT Project Ltd.
account of the T&T Projects Limited. Full stop. The Honorable Counsel for the petitioner has submitted that that the petitioner has already appeared before the investigating authority and has
Statement
made a
also.
statement, and he has also made a statement that the accounts of the petitioner have been freezed during the pendency of the investigation.
Yes, Lord.
Full stop. The petitioner accordingly, the Honorable Counsel accordingly prays that the petitioner that the interim bail granted to the petitioner may be made absolute during the pendency of the investigation. Full stop. The learned APP has submitted that the petitioner has in fact appeared before the investigating officer. Full stop. In this court is of the opinion that the further custodial interrogation of the petitioner, who is the wife of the accused, may not be necessary during the investigation since she has appeared and participated. Accordingly, the interim protection granted to the petitioner is made absolute. Sentence before that, you write in one sentence, Mr. So-and-so appears for the informant and has assisted the learned APP in objecting to the bill rate. Then you go back to the end. Accordingly, the interim protection granted to the petitioner is hereby made absolute, subject to the condition that the petitioner shall cooperate with the investigation as and when required. Any failure on the part of the petitioner to cooperate with the investigation may be brought to the notice of this court or with prayers for cancellation of bail.
Deeply obliged.
Item 31 and 32, she wants it on. When do you want it?
After 1 week.
After 1 week. What do you say?
We are in jail.
They all arise from the same FIR.
Same, but we are in custody and they are in.
Or you are in custody?
Yes.
You want
34
years here, you want to do it?
I want to do it.
In item 31, 32 and 33, you say, although this case diary has been received, the learned counsel for the petitioner has paid for an accommodation today due to personal inconvenience. Accordingly, this is item number 34. 32 and 33.
My lord, here what has happened, CD received, my lord, but the postmortem report is not yet received. My
Just a minute. Accommodation today and have the matter listed after a week. The learned APP has submitted that the postmortem report is yet awaited. Accordingly, list this AB item number 32 and item number 33. On, we'll take it up on 29th of April. 29th of April, awaiting the postmortem report.
My lord,
The interim protection granted earlier continues to.
my lord, in this particular case also, 34 also, that postmortem report will be required.
He wants to take up the matter.
My lord, that
If he now says that, okay, we'll await the postmortem report, we can have it checked along.
because one person died, my lord.
We'll have it on 29th, or we want to do it today without the PM report?
Because there is no allegation against us here.
There is no allegation against it. Then here the.
And admittedly,
There is no allegation.
My lord, in that respect, I will have to go through because otherwise, here the
Where
postmortem.
is the FIR?
FIR page 11.
Page 11.
Admittedly, there is a dispute regarding a land. And there is a cross FIR also there.
Accused number 1 assaulted my husband. We took him to doctor, treatment. Yes.
We are not, it was not before your lordship. We are the brothers of the ex-man.
Just a minute. তলত নাম দিয়া পদকীয়াখনে হাতত দা লাঠি ডেগাৰ আদি লৈ আমাৰ মাটিত দলে বলে আহি আমাৰ মাটিত ঘৰৰ পৰা উলিয়াই দি আমাৰ মাটিখিনি দখল কৰিবলৈ তেওঁলোকে ভৰ উঠায়। তেতিয়া মোৰ স্বামী ইমান, মোৰ ভাতৃ ইমান, স্বামী দেউৰক বিয়াত পদকীয়া গণে লাঠিৰে মৰিয়াই গুৰুতৰভাৱে আঘাত কৰে। 1 নম্বৰ পদকীয়া মূৰত বেয়াকৈ আঘাত কৰাত অজ্ঞান হৈ পৰে। Yes.
Page 32, cross FIR is there.
Huh?
They came to our.
Whatever happened at page 13, you said that there is no allegation against you. At
This
page
is
13,
allegation.
পদকীয়া গণে পিতে।
But there is.
Now, whether it was a lathi blow or whether it was the dow blow, PM report would be necessary.
Necessary, my lord. One person died, my lord.
We are ready to close it, no problem. Without the PM report, we can close it now. Perhaps it will be better if we await the PM report. Huh? You take it on that one, 32, 33 and 34, all three items together. Huh?
Admitted there is a dispute regarding a land and civic.
Understood, but only issue is whether you had any role in the death. Lathi blow to the hand, you are entitled to a bill.
FIR says that accused number 1. Yes, sir.
In such kind
Let us
of
read the FIR again. We'll just put you at ease. Where is that FIR? Page 18?
11 here.
Page 11. পদকীয়া গণে মোৰ স্বামী দেউৰেক আৰু ভাতৃক উপৰ্যপুৰীৰ ৰাতিৰে আক্ৰমণ কৰে। Is it?
Middle portion, accused number 1 assaulted on the head of my husband. And he became senseless, we admitted to hospital and then died.
Whether there was any other injury to him or not, if it is a...
Such kind of cases, that specific overt act is not necessary. All persons are...
All persons when you're carrying lathis and everything.
On 29?
Item number 32, 33, 34, all on 29th, huh? Same order.
CDB retained, my lord. I will call for
CDB retained, the APP, learned APP may call for an updated, for the postmortem report.
Publish.
70. Okay, anymore.
May I please your lordship? Which you FIR in page number 16, my lord. Lordship, may I read the FIR? এজাহারকারী সম্মানপূর্বক বিনীত নিবেদন এই যে তলত উল্লেখ করা 7, 8 আর 9 নং আসামিগণে প্ৰায় 1 বছৰ আগৰ পৰা মোৰ ল'ৰা মনিৰুজ্জামানক হত্যা কৰিম বুলি মানুহৰ আগত প্ৰকাশ্য গাই ভৰাৰ উপৰিও কুচক্ৰান্ত চলাই আছে। ঘটনাক্ৰমে 24/11/25 তাৰিখে ইংৰাজী ৰাতিপুৱা 9:15 মান বজাত মই আৰু মোৰ ল'ৰা একেলগে কিল্লাহাৰত সাংস্কৃতিক সন্ধিয়াৰ অনুষ্ঠান চাবলৈ যাওঁ। উক্ত সাংস্কৃতিক সন্ধিয়াৰ অনুষ্ঠান চাই থকা অৱস্থাত তলত উল্লেখ কৰা 7, 8, 9 নং আসামিৰ কুচক্ৰান্তে আৰু সহযোগ লৈ হঠাৎ নিম্নলিখিত 1, 2, 3, 4, 5 আৰু 6 আসামিগণে মোৰ সন্মুখত মোৰ ল'ৰা মনিৰুজ্জামানক হত্যা কৰাৰ উদ্দেশ্যে 2 আৰু 4 নং আসামী পিছফালৰ পৰা সাবতি ধৰে আৰু 1, 3, 5, 6 আসামিগণে মোৰ ল'ৰাৰ পেট আৰু বুকুত চোকা অস্ত্ৰ ডেগাৰ সোমাই দিয়ে। ফলত মোৰ ল'ৰা ৰক্তচুৰি হৈ ঘটনাস্থলত পৰি যায়। তাৎক্ষণিকভাৱে স্থানীয় ৰাইজৰ সহযোগ লৈ গাড়ীত উঠাই গোৱালপাৰা চলেজ হস্পিটেলত ভৰ্তি কৰক। বৰ্তমান মোৰ ল'ৰা ভৰ্তি থকা চলেজ হস্পিটেলত ICU চিকিৎসাধীন অৱস্থাত হৈ আছে। So my lordship, my 3 limbs of argument. First on the FIR itself, my lordship. In the FIR, my lordship, I just read out before your lord that here is 9 accused, my lordship. Here FIR is clearly mentioned. The FIR is the informant who is the father of the victim. Victim is a minor and father who is the informant was on the spot present there. In the FIR is mentioned while I was walking with my son. In the FIR, my lordship, just read out the accused number 7, 8, 9. They made the conspiracy with their help. 1, 2, 3, 4, 5, 6. They are them. Here it is FIR, it is mentioned that 2 and 4. They have
held the hands.
They held the hand and 1, 3, 5, 6. They put the dagger and these things. So my lordship, my first limb of argument, in the case diary, the learned additional just where they got the bail. Apart from 1, 2, 3 number of accused, all the accused got the bail. So in the FIR, my lordship, I've just read out, it is clearly mentioned that offense. I'm not denying there is no offense committed. If this is the FIR is mentioned, if assuming but not admitting this fact, it is all are true. So if the other co-accused, my lordship, granted bail, so the learned friend story cannot be 180-degree statement as the FIR mentioned. FIR is the informant was on the spot present who's saying all of these accused 1 to 9. Now can my lordship, the other co-accused can defend themselves outside the court and they can enjoy the pre-arrest bail. Why can I enjoy the pre-arrest bail? First set of argument, my lordship. My second set of length of argument, assuming but not this fact that even some offense committed by my part also there. So that can be decided by a trial court. If something I have done, then I will be face the trial, my lordship. And the third limb of argument, my lordship, before is that the FIR section implicated apart from one section, none of the section implicated to me, my lordship. If your lordship kindly allow me, so may I just repeatedly go through that section where it is the FIR registered in the
My
section,
lord,
my lord.
here the CD is not received today, my lord.
So much interim protection might be granted.
No, my lord. No, no.
2-3 times.
Find serious of
A man has died.
man has died, my
A
lord.
minor has died.
I not died, he is a my lordship. He is a fit and healthy. This is my clear instruction, my lordship.
Okay, we'll take your statement. He has not died, therefore not rejected today.
My lordship, my specific instruction that he is a well and fit, my lordship. He is not died, my lordship. I am as an officer of a court, I am
We will produce
expressing
CD.
this court, my lordship. He is not died, my lordship.
Mr. Kaushik, when CD?
My lord, this is from Goalpara.
My lordship, tomorrow there is same set of cases there in this honorable court. Tomorrow, my lordship, I think court number 22 item, the court number.
Give us the numbers.
Okay, my lord, I'm giving right, my lordship.
List this application along with. Maybe it is there.
Maybe.
My lord. It's AB 605 2026. AB 0605 2026, my lord.
26, we just stated to be listed tomorrow.
Maybe.
AB 605.
Yes, actually, need to সোনকালে উলিয়াই দিম।
Deeply obliged, my lord.
Yes.
I'm sorry, my lord. I was in another court.
No problem.
Here, my lord, the case has been registered of those sections of law, my lord, all are available except 1091, that is attempt to murder, my lord. And another is that out 74, my lord, that is outrageing modesty of a lady, my lord. So these two are the non-billable section, and if your lordship goes through the FIR, my lord, possibly that 109 ingredients possibly not there, my lord. They say it was an attempt, my lord. So attempt was made to throw, my lord, this petrol filled bottles, my lord. So attempt were made, my lord. That is the allegation. If your lordship kindly go to the FIR, page 12, my lord. So because of political rivalry, my lord, we belong to a different, my lord, political leaning, my lord. And the informant side, as your lordship has seen, my lord, present ruling dispensation, my lord. So this is the FIR, my lord. And on the merit, another one line, my lord. Here, my lord, there is violation of that section 36, my lord. If your lordship kindly have a look at the arrest memos, my lord. Page 34, my lord. The signatures of, my lord, the family members or some person of the locality, my lord. That possibly is not there, my lord. This is the page 37. Is the
They were arrested on the spot.
On the spot, yes. Not. They were apprehended by the public, my lord, when they are
and handed over.
handed over.
And no one from the public signed the arrest memo.
As it is not there in 36, man.
It is not there in
Yes,
36. Yes.
My lord, without going to my lord, who is the ruling party and all, my learned friend is submitting, my lord. Without going, my lord.
No, first of all, take it from us. There is no ruling party. There
Yes,
is a
my lord, but
no.
But
there is a serving party. No one rules on the democracy.
Yes, but that is what I am.
Don't say ruling party.
Yes.
Say serving party.
Yes, without going, my lord. Now, my lord, going by the eyewitnesses, my lord, they are found, my lord, loitering in that place, and also, my lord, throwing glasses on the road, my lord. That road, on the road through which, my lord, the people, my lord, with the my lord, rally has to pass, my lord. That is, they are doing, my lord, and
that is public nuisance.
Public nuisance, my lord, nuisance, and also, my lord, what they found, my lord, from the witness of the my lord, petrol pump owner, my lord.
Petrol pump owner.
Yes, my lord. He stated that from the CCTV it was found, my lord, that they are filling, my lord, petrol in the bottles, my lord, and my lord, they are trying to, my lord, cause nuisance.
Where is the seizure list?
Seizure, this, my lord.
Although this is
seizure,
not
yes,
connected to
seizure,
the-
yes, seizure witnesses are there, my lord.
Where is the seizure list?
Seizure list,
Where is the seizure list, sir?
It is in the CD, my lord.
Huh?
It is in the CD.
What all have been seized from them?
My lord, as per the, my lord.
Huh?
Prepared as,
What all has been seized from them?
I go to a petrol pump, I take, then my lord, I don't use it, my lord, whether it will be 307,
You are
attempt to murder, my lord.
when you are buying petrol in a bottle, you are supposed to use it
My lord.
in the vehicle.
Vehicle, yes, my lord.
Where did you use it is what we are trying to see.
yes, my lord. My lord, the intention is, my lord, sufficient, my lord. Along with search the illegal articles, commission of particularly the broken pieces of glasses, broken pieces thrown on the road by the accused,
and
broken pieces of glasses, and my lord. Seizure menacing. Produce him as an case for report produce. Yes, broken pieces of glass were seized, man, from them, man.
broken pieces of glasses.
Yes, madam.
So petrol already gone from the glass.
Petrol gone.
There can be no attempt. Other sections being bailable.
Other sections are available, madam.
Yes. So seizure is of broken glass. And what was the other section? Outraging the modesty of a woman. Now that any FIR by any lady saying that they had.
Yes, madam.
No, any FIR by any lady.
No, they have given their witnesses, madam.
Any FIR by any lady saying that yes, I was.
Is not clear from the.
I was touched or I was.
Yes, but the statements were given by the lady.
What is the statement given?
Statement were given.
Shall we see?
Yes, yes.
Can it be read out or shall
yes,
we
yes,
see ourselves?
Yes. By seizure witness. প্ৰায় ইমানটা বজাত মলাপাৰা চৌকৰ ওচৰত উপস্থিত আছিলো সেই সময়ত অসমৰ মাননীয় মুখ্যমন্ত্ৰী জন আশীৰ্বাদ যাত্ৰা কাৰ্যসূচী তেতিয়া ফৰ দ্য নেমছ মাই লৰ্ড তেতিয়া পৰাগ চক্ৰৱৰ্তী এণ্ড আদাৰ্ছ এণ্ড অলছ' দিছ পিটিশ্যনাৰ হৰে কৃষ্ণ পেট্ৰল লৈ সন্দেহজনকভাৱে আচৰণ কৰি আছিল আমি কিছুমান স্থানীয় মহিলাই লোকক এনে কাৰ্য নকৰিবলৈ বাধা দিবলৈ চেষ্টা কৰোঁ তেতিয়া পৰাগ চক্ৰৱৰ্তী আৰু তেওঁৰ সহযোগীসকলে আমাক অশুভ আচৰণ কৰে আমাক লাজ লজ্জা ভংগ কৰাৰ চেষ্টা কৰে পিছত পুলিচৰ হাতত অৰ্পণ কৰোঁ that is possible.
When there is no recovery of anything which can relate them to the petrol thing, if people had apprehended with petrol,
madam,
nothing handed over, nothing seized,
yes,
broken pieces of glasses.
The list is not here, man. That is what I am saying. The my lord, original list, madam. Yes, that is what I am confirming, madam. Original list, sure.
Heard Mr. R.L. Learned Counsel appearing for the petitioner also. Heard Mr. Goswami Learned Counsel appearing for a learned APP full stop. The case diary had been called for by the order dated 6/4/2026 and has been received. Did I say R.L.? H. Audrey. I make that mistake every time. I don't know. Mr. H. Audrey. The petitioner also heard Mr. Goswami. Huh? The petitioners had been arrested in connection with Nalbari PS case number 45 of 2026 under section 189(2)/191(2), 126(2), 1091, 74 and 61(2) of the BNS 2023. Mr. Chaudhary has submitted that all the sections barring section 1091 and 74 leveled upon the petitioners are bailable. Full stop. The learned counsel for the petitioner has drawn attention of this court to the FIR lodged against the petitioner, where allegations had been leveled that the petitioners had attempted to attack the convoy of Honorable the Chief Minister with petrol-loaded gallons, lighters, and broken glass bottles, etc. And when they were stopped by the public, they had outraged the modesty of women who had accosted them. The learned counsel for the petitioner has submitted that the arrest of the petitioner was not in accordance with law, since the arrest memo under section 36 of the BNSS does not indicate that the arrest was witnessed by any independent witness, although the allegation is that a large number of people had accosted the petitioners and handed them over to the police. The learned counsel for the petitioner has further submitted that no petrol-filled gallons, etc., had been recovered from the petitioners, although it was alleged that they had been apprehended on the spot while trying to attack the convoy, and only some broken pieces of glass have been shown to be seized by the police authorities.
Yes, and another seizure, my lord. Another seizure, my lord. The CCTV footage, my lord, which shows that he was filling petrol in the plastic containers, that has been seized, my lord, indicating that he was in possession of the petrol, my lord. That in the pen drive, my lord. Yeah, that was seized.
Accordingly, the learned counsel for the petitioner has submitted that the petitioners are ready to cooperate with the investigation and even if they're released on bail during the period of investigation. Full stop. The learned counsel for the petitioner has submitted that they are local persons of the area, and there is no local, well-recognized persons of the area, and there is no chance of their absconding or avoiding investigation or trial at a later stage if charged sheeted. Full stop. The learned APP has submitted that not only broken pieces of glass had been seized from the petitioner, CCTV footage of the petitioners filling up petrol gallons with petrol from a petrol pump have also been confiscated by the police. Full stop. He has submitted that releasing the petitioner on bail at this stage may hamper or tamper with the investigation process.
Yes.
Having gone through the reports and after hearing the learned counsel for the parties, this court is of the opinion that the arrest of the petitioner, being in violation of the requirements of Article 36 of the BNSS, and further the absence of recovery of any incriminating materials, save and except broken pieces of glass from the petitioner.
No, my lord, it's lordship.
The petitioner.
Yes, man.
The recovery from the petitioner is only broken pieces of glass.
Because and other witnesses are there, my lord, from the spot there. Yes.
The recovery is only recovery of only broken pieces of glass. The petitioners are entitled to the privilege of a bail. The investigation in the FIR lodged on 9/3/2026 has also substantially progressed in the meantime. The learned counsel for the other learned APP has submitted that there are witnesses incriminating the petitioner on the allegation of their outraging the modesty of women. Stop. Be that as it may.
Two petitioners.
Be that as it may, this court is of the opinion that since the investigation has progressed sufficiently, and also the length of detention of the petitioners, the petitioners shall be released on bail on furnishing bonds shall be released, the petitioners, namely so and so and so and so, shall be released on bail in connection with Nalbari PS case number 45 of 2026 on furnishing bail bonds of rupees 50,000 each with 2 sureties of the like amount to the satisfaction of the
Learned
CGM.
Learned CGM.
CGM Nalbari.
Learned CGM.
Nalbari.
Nalbari, full stop. It is provided that the petitioners shall cooperate with the investigation and shall not try to influence or threaten any witnesses in the matter. Full stop. The learned CGM shall be at liberty to impose such other conditions as may be necessary to ensure the participation of the petitioners
Yes.
in the investigation process. Any violation of the terms and conditions of the bail granted may lead to cancellation. May lead to cancellation of the bail.
Much obliged.
BA disposed of.
BA, madam.
Complex.
Some more recovery was required.
Yes.
Some more recovery was required. Yes.
May I please, your lordship?
Mm.
FIR was lost against financial irregularities, my lord. Financial irregularities in sanctioning the loan, my lord. And I'm going to submit, my lord, then the 34 accounts which were named in the FIR, 10 numbers of accounts has been closed since they have repaid the loans already. And the 24 accounts they are still paying the EMI, my lord. And this is the third time, oh my lord, it's paying for interim and all this. And the CD, I think CD has not been received from Polakvari.
Who are you related to the bank?
So I'm the service manager, my lord. Service manager. I'm working as service manager.
These loans were issued in names of persons who did not have salary.
But they
Is that
are
the allegation?
Yes, yes, my lord. But the other two accused, they have already been granted bail, my lord.
Where is it?
I have annexed it. Page number 23. It is an interim order, but already they have granted bail, madam, the other two accused.
Pre-arrest bail is rejected, page 25.
My lord.
This is for you. Okay. Page number 23, where is it?
This made absolute, my lord.
Yes, what do you say, sir?
But here that CD is up to date till 6/3/2026. Some because my lord here only the officials, the bank officials, their statements are here, my lord. But perhaps my lord, some updation is required here because the victims are different person, my lord. So far the statement of the bank manager is concerned, my lord.
Have you gone to the last order?
My lord, this is page
142026. Order dated to 142026.
No, that order, my lord, I have not.
Learned APP fairly submits that he can take instructions regarding the contention of the Learned Council regarding the closure of the accounts and paying of EMI in regarding to the remaining bank account.
My lord, then I will have to check.
If there is no lost cost to the bank,
my lord,
criminality would not come in. Disciplinary proceeding is something else.
That is different. That is different.
Is it
That
not?
is different.
But you have to get us that instruction.
My lord,
she is
then-
without a interim.
Tomorrow or day after tomorrow, my lord?
Just that much of information.
My lord.
The statement was made that 10 accounts
My lord.
already fulfilled.
My lord.
And 24 accounts, regular installments are coming in.
My lord.
There's no
If that be so,
peculiar- Yes, madam.
whether there is a criminality in it,
My lord. That because here once
or should we allow an interim, allow her to appear, allow the accused to appear, along with the statement that these are the accounts which has been done.
My lord.
Your investigation will proceed.
My lord, that can be also done. Here, one thing is there, my lord. Only I am just like to point it out. He was the branch manager at that time, and that
He was a
person-
service manager or a
He-
branch manager.
No, my lord. One branch manager. His statement is here, my lord. Because this person and another co-accused, and I have seen, my lord, in her petition that co-accused has been granted interim. My lord.
Interim.
And they are the person, they usually verify the documents and all that, and that manager approves, my lord. So some anomalies happen in there, my lord, while verifying.
The other two co-accused have already been in bail.
We'll allow her the interim.
My lord.
She goes and appears before the IO, gives them all the detail of the bank account. Let him verify, come back with an updated CD.
My lord.
Huh?
My lord.
Heard Ms. Gogoi, learned counsel appearing for the petitioner. Also heard Mr. Kaushik, learned counsel, learned APP, full stop. The updated case diary sought for by the order dated 142026 has not been received till date, full stop. The learned counsel for the petitioner has submitted that the petitioner is eager to appear before the investigating officer to participate in the investigation and to give appropriate evidence that 10 of the accounts have already been closed and 24 beneficiaries are also paying their installments regularly, full stop. Considering the submissions made by the learned counsel for the petitioner, this court deems it fit to allow one opportunity to the petitioner to appear before the investigating authority to put forward her side of the story, his side of the story, and have his statement recorded. Accordingly, the petitioner shall appear before the before the investigating officer on or before 4th of May, 2026 to participate in the investigation. List this matter again on 11th of May 2026 along with the updated case diary. It is provided that in the meantime, if the petitioner is arrested, he shall be released on bail on executing a bond of rupees 20,000 with one surety of the like amount, subject to the following conditions. Page 29 of the petition. There are a few conditions. You will not take condition number 1 is not necessary, and 2 and 3 will be there.
I'll
Being a item 12.
No,
My lord,
rest out.
I was supposed to
Trace out.
raise out, my lord. My lord, what really caught the attention is in para 3, my lord. That is what for your lordship. The document is in page number 16 of the writ petition. There's a type copy.
Order to question again.
Phrase 1, I request.
You have a better copy of page 17 with you, sir?
Number
Page 17 of the writ petition.
Yes.
Page 17 of the writ petition. Do you have a better copy of it?
My lord, the department, the secretary told me that, my lord, still they have some apprehension about this and now they are digging it.
Page 17, do you have a better copy of
It's a printed copy, and page 17, it is the original copy.
that original copy with us is
Yeah.
very illegible.
How
you have given a typed copy, but there are certain differences in numbers in the typing.
Yes.
Therefore, I am asking you, do you have a better copy of page 17 with you. From where did you type it? 17 is not readable. There must be a better copy.
As of now, it is not available, but I will try to update if necessary.
We will give you 2 weeks time to place a better copy of the page
Better.
17.
Yes, we can do it.
What has happened is this, the department has some apprehension
Lordship.
that this may not be a genuine document. Therefore, we must know the correct numbers so that the file can be traced out accordingly. If you see at page 17, after the name of the incumbents, page 16,
Yes.
this has been issued with concurrence of the finance.
Finance.
SCIIT. There is no such thing called SCIIT in the finance. It is Roman 3 as we read it.
SCIIT.
Then you say department conveyed via EC Roman 2T. Here it is via EC Roman 3. Numbers are not telling.
Yes.
So if you can get us a better copy, we will have the correct numbers.
We did 2 years ago, sir.
Huh? The learned counsel for the petitioner has sought for some time to produce the original of the annexure number 4 given at page 17 of the writ petition. The learned additional senior government advocate, Mr. Ardhar, has submitted that without a proper legible copy, the file numbers are not traceable. And there appears to be some discrepancy in the typed copy, full stop, allowing the learned counsel for the petitioner to produce a better copy of the annexure number 4. Release this matter again after 2 weeks.
Yeah, Lordship, that may be also fixed.
But okay, more than a month, it's gone. Release the matter again on 30 April 2026. Matter will not be treated as part heard.
My lord is fixing on 30th April. My lord.
For him to produce the copy.
My lord. No issue, my lord. Fine with me, my lord.
Or we'll put it up on the 6th of May. 6th of May.
My
Later, 2 weeks.
My lord.
Not to be treated as part heard, huh? Yeah, please. Oh, I'll just come back in 2 minutes. Huh? Yes.
Item 20. I'm taking item 20.
20 and 21, madam. There is an order for updating the CD, madam. It is not updated, madam. He is on interim, madam. I pray, madam, let it come after 3 weeks, madam.
Mr. Goswami, learned PPP, has paid for an accommodation of 3 weeks to produce the updated CD.
Lordship, on my kindly fix on 11th of May, madam.
Let the matter be fixed again on 11th of May for production of the updated CD.
Updated CD, madam.
The petitioners are on interim protection. The protection continues till the next date of listing.
Obliged.
I'm taking item 15 and 15.
May to the lordship. My lord, this is as big as Jimba of my vehicle and other mobile phones and others.
Yes. CDN report.
In this regard, my lord, we obtained, my lord, one report, my lord. As because, my lord, this case, my lord, vehicles were seized and also, my lord, some bank accounts were, my lord, that is the frozen, my lord. Now, my lord, this prayer of the, my lord, there is the petitioners before your lordship regarding the, my lord, defreeze the account and also, my lord, releasing of the vehicle, my lord. So we get a report, my lord, as per the report, my lord, that, my lord, The vehicles, my lord, those who were, which were purchased, my lord, it is on, from the, my lord, that transaction, from the, that money in questions, my lord. And my lord, that is, my lord, regarding, my lord, that is, there is the defreezing of the account, my lord. The still, my lord, my lord, that is, the investigation is going on, my lord. The investigating agency categorically, my lord, in detailed report they provided, my lord. At this stage, my lord, may not be, my lord, granted, my lord. That is the humble prayer, my lord, may kindly peruse, my lord. That is the report, my lord. In each paragraph, my lord, they give the details. And also, my lord, in this case, my lord, some prima facie evidence are there regarding some, my lord, that is the electronic evidences, my lord, from CCTV footage and all. Otherwise, it will, my lord, hamper, my lord, at this stage, my lord, if it is given.
What was the FIR?
FIR is at page, my lord, 20. Your lordship promised me other one submission, my lord. Before seizing and freezing, earlier 202 and 106 has been complied with or not? Before seizing and freezing, bank account. Earlier 102 CRPC, now 106, whether that has been complied with. It is mandatory. If it is not, totally bad. My lord, and I rely on this judgment of this court. No, also 106 to CLPC, BNSS.
Which part is required to be complied with?
My lord, 106 now, my lord, if your lordship takes up 106 3. 106.3. Earlier it was 102.3. BNSS 106.3.
Which part?
My lord, every police officer acting under subsection 1 shall forthwith report the seizure of the magistrate to the magistrate having jurisdiction whereas the property seized is such that it cannot be conveniently transported, then my lord provided. provided why the property seized under subsection 1 is subject to speedy and natural decay, the person entitled to the possession of such property is unknown or absent and the value of such property less than 500, it may forthwith be sold, but it should be informed to the magistrate that this property has been seized and this shall be freezed. That has to be informed to the magistrate, whether they have complied with the document. In between that interim period of seizure and freezing. Whether if they have not done, it is bad. Shall forthwith report the seizure to the magistrate, jurisdictional magistrate, as regards the freezing of the bank account. And as regards the vehicles, my lord, I will rely upon the judgment of that Sundarlal Ambala Desai, that it should be within 15 days, whatever it is, that has to be released, as regards the vehicle and mobile phone. It was purchased for that amount or not.
Here the matter was remanded back to the trial court to consider defreezing of the account. I think in your case, the trial court has already considered it and rejected it. So this would not come to your
But
aid.
that mandatory provision, that will not for remanding back, but not here, your lordship may set aside this order and remand back to consider it again with that provision of 1063. And my lord, as regards vehicle and mobile phone, that 2003 Sundarlal Ambala Desai, within 15 days it has to be submitted, man. This is the judgment, man.
15 days it has to be submitted to the magistrate.
My lord, 15 days it has to be returned back. This is judgment.
Yes, tell us. The Seizure, your report says,
My lord,
that these have been brought from the proceeds of a crime.
my lord,
Why do you need to retain it with you?
my lord. My lord, regarding the vehicle, my lord, the parties that my lord Sundarbha Ambala Desai is a my lord, that is a my lord authority relied on by giving my lord bank guarantee, my lord, as because my lord here, my lord, in this case, the investigation reveals till now, that is my lord, the money in questions, my lord, that is used for that. It is, my lord, it will come out or not, it's a different thing, my lord. So, my lord, along with the bank guarantee, my lord, as part of the provision of law, that may be, my lord. But regarding, my lord, regarding the, my lord, there is the mobile phone numbers, my lord. Because, my lord, at this stage, I am not able to, my lord, submit before your lordship whether, my lord, that this is required for, my lord, that is the FSL or not, my lord. There's the mobile communications and all this, my lord. That
FSL for mobile for finding out the communication.
because, my lord, there are 3 numbers of, my lord, that is the, my lord, accused they are in this case, my lord. Before your lordship, my lord, 2 numbers.
When were they seized? The mobile phones?
My lord, it is a, my lord, matter of, my lord, 1225, my lord. 1225, my lord, December 25, my lord, matter.
4 months,
my lord.
We have not proceeded. And here he has not said about the mobile phones, has he? In the report. In the report, does it talk about the mobile phones at all? Huh?
Vehicle and that part is there, man.
He is talking about the vehicle and the transaction.
Transaction, man.
He has not stated about the mobile phones.
So because of that, my lord, I am not in a position to, my lord, make this submission because that is not available, my lord. My lord, so my lord, let my otherwise, my lord, a report may be called for, my lord.
How many times you will call for a report?
My lord.
You have to understand one thing.
My lord.
When I say you, I mean the investigating authority.
My lord.
When the prayer is for release of 3 things.
My lord.
And he does not refer to one of them.
My lord.
To be required.
My lord.
What is the assumption? Not required.
My lord.
Is it not? So far as the bank account is concerned.
Yes.
You have seized the entire family's bank account. Everybody's bank account. People are saying don't do anything without a bank account. How does the family survive?
Right.
UPI will also not work.
Right.
So you're pushing everybody to cash transactions. That is what you're trying to catch. How does it work? In case you want to have some instruction on the 1063, as he says,
My
and the judgment of this court.
My lord, because my lord, for that, my lord,
I
I
can
have to
allow
check,
you
my lord, whether, my lord, that is followed or not,
I
my
can
lord.
allow you a day or two on
Yes.
maximum on that.
Yes, my lord,
Vehicle
my lord,
with bank guarantee
my lord,
has to be released.
my lord,
And the mobile phones,
my lord,
nothing being there on the report,
my lord.
we'll assume that it is, you don't have anything to say on the bank, on the mobile phone.
My lord.
When will you have it, 1063?
My lord, one day, my lord, will be given, my lord.
We'll take it up on Thursday, 23rd, sir. You are here?
23rd is not possible. 22nd, man. Or tomorrow is 22nd. 24th?
24th, my lord.
At the request of the learned APP, Mr. Sure, let this matter be listed again on 24th,
my lord,
of April.
Well,
for further consideration.
my lord, deeply obliged, my
Vehicle, there should not be a problem. Phones, they are not saying anything.
Next item, same man, same affair, another person.
Same. Huh?
Same.
Second item. Item 12 and
14 and 15, my lord.
14, 15. Do it
14.
list on 24th of April. Huh?
My lord.
Same affair,
Obliged.
only different. Is a problem. That judgment may remain with that record, the judgment.
Now, one judgment I have kept here, book I have returned. এখন হেৰি person গৈ পেলাই কৰিছিলে যে থৈ দিয়ক এনেই থৈ দিয়ক marked as an extra list এনেই থৈ দিয়ক ফাইলটোত 12 ধৰ এপিয়াৰ কৰিছিলে yes sir.
Make with the lordship, the interim is there, lordship. After interim, the petitioner appear before the your lordship, and his track was released.
His track was also been released.
My lord, here, whether he appeared or not, that is not reflected in CD. CD, we need up to date, my lord. Statement is
If he released his track, lordship. After
The
order,
track has also been released.
lordship, the page 17, lordship. Lordship, this honorable court is passed the Jimma petition, criminal petition.
First the track, then the person. Huh? First the track, then the person. The learned counsel for the petitioner has submitted that the petitioner has appeared before the IO and cooperated with the investigation. Learned APP seeks some time to have an updated case diary. List the matter again on 11th of May. Interim order passed earlier. Continues. Learned APP check. 11th of বহুত হৈছে. On the 13th of May.
Diploma.
Pass over for that day.
Why?
but 30th CD not received.
It is out of station.
Huh?
Lordship. What's the date? Lordship call for CD.
Hmm? 22-year-old girl running away with someone.
My lord.
Huh? Have you seen the affair?
Yes, my lord.
Major girl has eloped with someone.
ঘৰৰ পৰা নোহোৱা হয়।
We'll allow him to appear.
But here, because seems like that, my lord, there are cases, my lord, we have come across. My lord, on the pretext of false marriage and all these things, my lord, sometimes this human trafficking goes on, my lord. So
Apparently, the lady has gone back to her house on a phone call. If you see, page 3. On a phone call, the lady went back.
my lord. Oh, lordship may fix it on Friday.
Friday?
Friday.
List the matter again on 24th of April, allowing the APP to call to produce this case diary. Girl is recovered. She has gone home.
Gone home.
22 years of age.
I don't know. I just want to see her statement. And
He has admitted that yes, she came to my house.
yes, ma'am.
Phone call came, she went back.
My lord.
If she says that I was in love and I wanted to marry him,
Then no case.
matter over.
Matter
Why
over.
should he? Why should he?
Yes.
He's a student of the university.
University, ma'am. I just want to go through her statement, ma'am.
Friday. Item 40.
Yeah, please.
Yes, madam.
The matter is fixed for taking the steps. We have already taken the steps. Not any report has come so far.
Eight four is the last.
Yes, your lordship.
The office note dated 8/4/2026 reflects that notices had been issued
Yes.
by speed post on the respondent number 1. However, service report is not available. List again on 6th of May, awaiting the service report on the respondent number 1. Miss M. Kumari, Learned Standing Counsel, CBI, appears for the petitioners.
Much obliged.
None appears for the petitioner on call list again on 29th of April 2026.
Item number 44.
Hmm?
Item number 44.
Yes, tell us. Yes.
Lordship, on the last date, the court had directed to place an order of a similar matter that was disposed of by the coordinate bench of this court.
Where is it?
Lordship, on the same cause of action. Actually, the matter was that was also dismissed for default on the same cause of action, and that was reinstated with the coordinate bench of the honorable court. Lordship, kindly
Was allowed by the court. Another similar matter was allowed by the court.
allowed by the court.
Was
On
it
the same
allowed?
cause of action only. On the same cause of action
Then
only.
what happened?
That was directed to place before this honorable court.
Show us. How do you say same cause of action?
Lordship, it was the same parties only. Actually, the matter was that NI Act was dismissed for default on the same cause of action, and we had also filed another matter for criminal breach
You
of
had filed two complaints.
before the
Both were dismissed for non-prosecution.
non-prosecution.
You had approached this court by two revision petitions.
Two revision petitions.
Two
separately.
petitions.
Two
Two criminal
petitions
petitions.
separately, because there were
Separately.
two
One of them has been allowed by this court, allowing you to prosecute.
Lordship.
And you want this case also to be?
Lordship, same cause of action only.
Where
that
is
was also
the
dismissed for-
respondent number two?
Only there is one respondent, Halaluddin. I'm for the Mina. There is only one respondent, Lordship. Private respondent, Lordship.
Service is not complete on them. Can we pass an order?
Lordship, but it can be disposed of because only the Honorable Court of Hosai had dismissed for non-prosecution, dismissed for default. And Lordship, they are means the opposite. The another case is actually it has been ongoing in Hosai Court. So the opposite party is in knowledge that we had also filed another matter in Honorable High Court. So it can be disposed of, Lordship. There is not so much technically, Lordship. Not so much technical.
Without hearing the other party, can we pass an order? Where is that order? Order?
Impin order is at page number 18, Lordship.
Page number 18?
18. Lordship, my basic ground is that I live outside of India. I carry business in Thailand. So on the dates where the case was listed, I could not contact my engaged advocate at Hojai. And he also failed to intimate me about the dates of the CR case 72/22. So on account of non-prosecution, the case was dismissed for default.
What was the date of your dismissal of the other case?
Lordship?
23/6.
23/6.
Disposing it off on the same lines, huh? Order to get issued. Corrections of pre-issue. Date bill. Itu order ready. Disposed of.
Highly abused.
Item 45.
Completed. So this revision petition is filed against order passed the learned Chief Judicial Magistrate rejecting the prayer for maintenance. That's it.
Why was it rejected?
Let's see, main grounds, let's see. The petitioner sought maintenance after about 8 years. she did not claim for her maintenance earlier, let's see. Another ground, let's say, the second party remarried, so the first party did not wanted to live with the second party. Let's see, judgment starts, let's see, page 22. Let's see, may I kindly turn to page 23, let's. May I read the judgment. The present case arose out of an application under section 125 CRPC filed by the first party, so against the second party, claiming maintenance at the rate of 6,000 per month. The first party's case inter alia is that on 8/10/02, the second party married her as per Islamic Sharia by fixing den moher at rupees 2,10,000, and thereafter took her to his house and resided as husband and wife. Thereafter, the second party demanded excess dowry, and upon her failure to give dowry, the second party tortured her mentally in various ways, and in the month of August 2005, chased her away along with 3-year-old son. Thereafter, she was compelled to take shelter in the house of her widowed mother, as she has to take care and attention of her son and has to send him to school. She has
You've
not
seen
been.
that now the court has said that you did not ask for maintenance for
Let's
9
see.
years.
Let's see.
Thereafter, there is no allegation that he refused to maintain you.
Let's see.
You have not made any statement that he refused to maintain you. Rather, your statement is that you have left his company,
Let's see.
companionship, and you have gone and stayed with your mother.
Let's see.
After everything ended for many years, then he got remarried.
Let's see.
So that remarriage is not during the subsistence of the earlier marriage, because already you had accepted the 3 talaqs.
Let's see. As per the time, let's see, time of filing the application, let's see.
You had filed an application in 2005.
Let's see.
You did not claim any maintenance.
No, at that time, she claimed for her son, let's see. That was for son.
And was it allowed?
Let's see.
It was allowed and it was paid off.
When, let's
We were paying that.
And when, let's say, son got matured, let's say, then she closed that.
However,
That
she
When
has
the
filed-
son matured, when the son, what matured?
Let's see, in the meantime, let's see, the respondent has filed one affidavit, let's see, on 9/10/25, let's see. There, the order is annexed, see, page 39 of his affidavit, let's see.
Okay. He attained majority in 2023, and therefore that maintenance has now stopped.
Let's see, let's see.
So
She had filed a petition. Yes.
She
So now-
filed this application, let's see, in 2012, July, let's see. And order was of 2014. Rejection order was 2014. Then revision petition was filed. let's see.
So tell us where is the magistrate wrong in saying that you are not entitled? You did not demand it.
Let's see, as per 125, let's see, the applicant has to say that she is unable to maintain herself, let's see. 125, let's say. Subsection 1A, Lordship. His wife unable to maintain herself. That is sufficient, Lordship, to grant maintenance. And time period is not prescribed by the Act, Lordship.
If you start living separately on your own volition, then what happens?
Lordship, his second marriage, I cannot prove, Lordship.
No, not necessary. What we are saying is, in your evidence, you have said
Lordship,
that you had a quarrel
Lordship,
and you went to live with your mother.
Lordship.
So the allegation that he pushed you out is gone. You went on your own volition. Now, if you go and stay with your mother because you want to, why should he maintain you? Page 7 of the judgment.
Lordship, due to the quarrel, she could not live, Lordship, together. So she went
Little
away.
quarrel when you live on your own. I don't want to stay with you. I'll go and stay with my mother.
After the quarrel, she left. Lordship.
But there was no force for her to leave the matrimonial home. She went out by herself.
Drove away is her statement, Lordship. In her application, Lordship. She was drove away.
The learned trial court says first party was not chased away, but she left on her own volition. Now, if she leaves on her own volition, can we allow a maintenance?
Lordship, in her application, she said she was chased away, Lordship.
In her application, but in her evidence, she says otherwise.
That's it.
In her evidence, she says otherwise. Your case for cruelty was also dismissed. He was acquitted.
But there is tax court judgment, Lordship, in maintenance case, Honorable Court should not go into merit of those other matrimonial cases.
No,
Lordship.
nothing. We are simply saying
That's it.
that given the circumstances where
That's it.
where you say that I had gone to live with my mother,
That's it.
the allegation of cruelty stands disproved. You did not ask it for the last 9 years.
That's it.
You maintained yourself.
And regarding the
Now, could there have been an order? And again, we are not sitting in appeal. This is revision. What is the fault in that order? You have to show us. When? Want some more time? When?
as per convenience.
No, it is your convenience. You come back with these answers. If you can answer this, we'll consider. If not, we can close it today.
Lordship,
These three questions. These three questions only. One, did you leave the house on your own volition? Two, cruelty being disproved, not proved in any of the courts. Can it be said that you were forced to leave? And three, 9 years. And after the second marriage, you come and say that I want a maintenance. Only these three questions. Satisfy us, we'll consider.
Regarding 9 years lapse, Lordship, one Andhra Pradesh High Court judgment is there. Could not find Supreme Court judgment, Lordship.
Well, Andhra Pradesh High Court judgment is fine. Here we are dealing with a person who is well versed in law.
That's true, Lordship.
It is not a person who does not know the law or who could not have gone to the court. Admission is I go to the court every day. I cannot stay after 2:30. Is it not?
Yes.
When do you want it? Say. At the request of the Learned Counsel, April, this is matter again on the 30th of April 2026. Three questions answer us, we will try. Obligation.
Obligation.
Yeah, please, Your Lordship. I beg to mention item number 31, which is fixed on 6 May.
The charge
Some
sheet
confusion in the morning also. Yes.
can the matter taken up on tomorrow or day after tomorrow?
After tomorrow, you will come. These confusions have to be cleared when you come to the court. Porohile? Kaile na porohile. Huh? At least porohile. Ne. 23rd? 24th of December. When did we fix it?
Tomorrow, day after.
No, when did we
6th
fix
May.
it? 6th. At best 28th. We can bring it to
Because,
28th.
my lord, we need CD, my lord, in this matter, my lord. So we pray for, my lord, 6th of May, my lord. CD, as because CD is not available, my lord.
Charged has been.
CD. Then, my lord, okay, they have some information that surgery is already being made. Then, okay, my lord. We don't have that information.
At best 28th.
20.
Bless, thank you.
39 to 20.
Yeah. So,
I think 39.
yeah.
Then আমি এন্ডে করব
46 to 52.
Let's see.
That IOCL matter.
Now, pre-lunch, are you available after lunch also? Can we continue? Sir. Which one do we take up first?
Item 46, man.
46 will take up first.
Yes.
Okay. We'll take it up after lunch, but
Yes.
we are just trying to coordinate how to go about it. 46. 46 to sounds. It is 46, 37 to 43.
But there is one problem, Manoj. There's another connected matter which we had pointed out last time also.
Yeah,
Another
there is-
connected matter which has not come.
Yesterday, some mention was made about that matter. And I had requested the council to remind me today morning so that we could have called for the record of that one also, if parties are prepared.
In that matter, affidavit has been filed? No.
We filed it yesterday on your lordship, but it must have not come on record.
No, that matter is not before us.
That's also.
That
there.
council is not
Different-
before us what to do. He made a mention yesterday. But we were not taking up the civil bench, so we said that he has to make a mention before the appropriate court stating that these matters are listed and may be tagged.
That I think he had made the mention before the senior bench. And perhaps he has been asked to go to the registry.
Okay.
If your lordship passes a judicial order,
In case he's here, then we can, otherwise, again, we have to take it up on some other day then. If that matter is necessary to be taken up with this
because
matter.
that matter and item 46 are directly connected. Item number 46 and 47.
46, you are appealing, sir.
Yes.
46
He says
is
that matter
appearing,
is connected.
47, my friend.
That matter is directly connected.
Yes, 46, 47 and the other matter.
Other matter have to be taken up together.
Yes.
Have to be heard together, at least to give everybody an opportunity.
Yes.
Do
you have the number of the other matter?
No.
The petition number? The connected matter, the number is 1380 of 26.
Twenty-two, 23 matters.
In fact, in your lordship's last order, there is an indication about that.
You may peruse the order dated 26/3/26 in item 46.
Including 1830 of 2026.
Yes.
That is the matter which is required to come. You made a submission that they can be heard without reference to 1380.
Yes.
We'll ask that matter to be here. We'll ask that matter to be brought here. Should we take it up on the 28th or should we ask for the matter to be brought here today?
28th, my lord, I have a lot of matters fixed. If it is not inconvenient, my lord, can it be 7th of May?
The 5th.
5th again, I may not return back.
Okay.
7th.
7th of May. What do you say? What do you say, 7th of May?
7th of May is fine, my lord. I was urging on the other matters, my lord, 48 to 52.
No, but
That if can be taken up today, my lord. Because your lordship will recollect that that part of the series has nothing to do with age relaxation, migration.
Should we take up the other matters today?
That is a submission, my lord, because what has happened, just to give a brief summary, there was a complaint lodged in item number 46. This Rahul Das and the other writ petition which is not before your lordship. These are the two persons who lodged a complaint saying that our cases ought to have been considered. So once we received those complaints, our internal
his job
investigation was
you had taken away his job.
Yes.
On receipt of those complaints, you took away his job without notice.
Yes.
No.
Which otherwise had nothing to do with me.
That is in 47. But in 48 onwards, what happened was there were anomalies in the markings that were allotted, which was discovered based on these complaints. So that is how there is a connection. It is not that they are totally disconnected. So your lordship may keep these matters also on 7th. They may be heard separately, that I am not objecting. But the foundation is in item number 46.
Because, my lord, item number 46 is earlier in point of time, and I think my party respondent has responded on 5. And the challenge is appointment. And if that is allowed, my lord, is
No, that I agree with my friend. So far as 47 is concerned, my lord, no difficulty, my lord. Obviously, these three have to be heard together. My lord, their complaint was basically that we were...
That all we have understood. If you agree, we'll take it up on the 7th. We have got very few cases fixed on the 7th.
Yes, sir.
So on 7th, we'll list all the matters together. And we'll take it up one by one.
Yes, sir.
2023, we'll take up first. Finish it off, then the complaint part. Then what has to happen to you?
No, my only anxiety was that...
Detagging also, we are not objecting. Even if it is detag, my prayer is let it be on the same day.
While hearing it, because our minds will be fresh on the matter. We can bring our judgment accordingly, how to handle which one. From where to go to
Because one of the new matter comes again, affidavits are exchanged unnecessarily, these matters.
We have already filed the affidavit.
And they have filed their affidavit.
But the general candidates are perhaps yet to appear.
See.
But the service, I think, is complete.
If that part remains, if the general candidates are not affected by our order. Only if they have if it affects something. Only then. Moment we see something is to be affected, we'll keep those.
Very good. Very good.
Then we'll dispose of all this.
Right.
But if you bring them together, perhaps this
11,000. All right.
hurdle will be taken care of.
Okay. 7th.
7th. At the consensus of all the parties. Please this matters again on the 7th of May 2026.
7th.
Along with WBC number 1373 of 2022. But that is already here.
Those are already there. The only one not here.
Along with WPC number 1380 of 2026. Full stop. It is the parties have submitted that although the matters may be listed together, a separate hearing in each of them may be required. The same will be considered on the hearing on 7th of May 2026.
Deeply obliged.
The same order will cover all the matters. Obliged.
Lunch. It is, বাকি কি থাকিব? After lunch. এটাটো সেইটো ফিক্স হ'ল আৰু হা? নমাই দিয়কচোন। বহাই দিয়ক এখন। বহাব পাৰিম নাই? হা? এখন গুচাও। এখন গুচা। হা? নালাগে এখন গুচা। গুচা। গুচো এখন। Yes.
My lord, before the respondent makes submission, my lord, I would like to make some submission. So far, my lord, clarification, my lord, as per the instruction of the petitioner, my lord. So far, the original is concerned, my lord. It is on all likelihood, my lord. It is written by the respondent, my lord, saying, my lord, this photocopy only he has. So this I have brought on record by way of affidavit, my lord. Second point, my lord, so far someone received, my lord, he has reaffirmed here again, my lord, he did not receive any summon from the, my lord, trial court, my lord, learned trial court, my lord. So when he through the counsel, my lord, try to obtain them to know the status of the case, at that time only he came to know about the pendency of the case, and through the lawyer only, my lord, certified copy of the impugned order as well as FIR was, my lord, obtained, my lord. But my lord, it seems, my lord, in the charge sheet, my lord, that most probably inadvertently, my lord, this certified copy is not there, my lord. But in all, my lord, fairness, my lord, this copies FIR, this charge sheet, my lord, it was obtained through the lawyer only, my lord, through the court only, my lord. And my lord, you will find, my lord, charge sheet copy, my lord, it will be available with your lordship only, my lord. It is not something, my lord, that any forgery or anything has been done with the charge sheet, my lord. This official, my lord, it was not provided to us, my lord. That's why we could not annex it. Otherwise, my lord, this FSL, it is in our favor, my lord. So otherwise, my lord, why should I, my lord, suppress this particular document which is beneficial to me, which is negative so far against the allegation of this forgery is concerned, my lord. But so far, my lord, last occasion, I have already argued most of the aspect, my lord. I will just, my lord, in brief, my lord, basic, my lord, my case, my lord, my contention, my lord. The contentions are three, my lord, basically, my lord. Well, so for the first part is, my lord, this bar under section 195 of the CRPC is concerned, my lord.
Yes. What are you saying?
My lord, my lord. Basically, my lord, I have three grounds, my lord, for filing this criminal petition, my lord. Praying for, my lord, quashing of the FIR and the charge sheet, as well as the, my lord, impugned order by which the cognizance was taken of this charge sheet and the summon was issued, my lord. First ground, my lord, I put it, my lord, that there is a bar under section 195, my lord, that when it is alleged that the document has been used, and the allege is that this is a forged document, then my contention was that this direct FIR is not maintainable under the law because section 195 there is a bar in the CRPC. But my lord, so far this law point is concerned, my lord. After my further research on this point, my lord, I will concede to this point, my lord. So far, this custodial legis is concerned, my lord, because this constitutional bench and subsequent judgment saying, my lord, that document has already to be in the custody of the court, and when the forgery is done, only at that time of this section 125 will be attracted. So far, this first part I will concede, my lord. I will leave my argument. So far, this first part is concerned, bar under 195, my lord. Now the rest two, my lord, that the impugned order, my lord, there is a series of judgment which says, my lord, that issuing summon and taking cognizance, it cannot be done mechanically, my lord. My lord, in the present case, my lord, has in last occasion, my lord, I have submitted one judgment 2025 SEC online SC 2008 JM laboratory case, my lord.
You can take your seat, sir. Yes.
My lord has got 2025 SEC.
Yes.
Yes, my lord. In this case, my lord, basic case para 6, 8, 9, and 10, my lord. It has relied in the case of Sunil Bharti Mittal case, basically, my lord, dealing with how the, my lord, cognizance has to be taken by the magistrate, my lord, and when the summon can be issued. And in this case, my lord, specifically exhaustively deal, my lord, this calling the witness, calling the accused, issuing summon, it cannot be mechanically done since summoning the accused is a serious matter, my lord. So some judicial mind has to be applied to the materials on record, whether there is a prima facie case to take the cognizance or to summon the issue, to summon the accused person or not, my lord. In this case, my lord, if sees the impugned order, my lord, kindly turn to page number my lord, page number 84, my lord. Page number 84. This is the impugn order whereby the cognizance was taken, my lord, and the summon was issued. My lord, this particular order, my lord, it doesn't disclose that, my lord, that judicious mind was exercised, taking into consideration the materials available on the charge sheet, my lord, and whether there is a prima facie case has been made out, warranting, my lord, issuing the summon, calling for the accused person, my lord. And all this judgment which I have relied, my lord, it's categorically said, my lord, this exercise has to be done, and in the order it has to be reflected that this judicious mind has been utilized, my lord. So this is one ground, my lord, that cognizance has been wrongly taken, my lord, without exercising judicious mind, my lord. Therefore, this cognizance order, my lord, is liable to be quashed and set aside, my lord. What was the second ground, my third ground, my lord? That, my lord, charge sheet, my lord, is already before my lord only, my lord, and the charge sheet which I have annexed with the criminal petition, my lord. My lord, since official report is negative, my lord, it doesn't support, my lord, and the manner in which charge sheet has been filed, my lord, it doesn't disclose any prima facie case or there is any sufficient materials, my lord, supporting that there is not a single corroborative materials, my lord, so far against the allegation, my lord, in the charge sheet, my lord. So in this case, my lord, this is not the case, my lord. As per the materials on record, which says that this is a prima facie case is there and the sufficient material is there to proceed further with the case, my lord. There is only the allegation on, my lord, and there is no finding even by the police during the investigation, my lord. This charge, this FIR, my lord, which is alleged to be forged, my lord, where it was forged, my lord, when it was forged, my lord, by whom, my lord, nothing is there, no finding is there, my lord, nothing is there, my lord. Only that it is shown, my lord, in the sketch map that this place of occurrence is inside the court building, my lord. So, my lord, under such circumstances, my lord, this is not the fit case, my lord, where a criminal proceeding can be set in motion against the, my lord, petitioner is concerned, my lord. So, on this prima facie, and this honorable court has 482 power, inherent power, my lord, whenever this abuse of the process, my lord, of the law, my lord, then my lord can always interfere. And my lord, kindly take into consideration this. As on today, the respondent has already filed 4 or 5 cases against the petitioner. This is also one of the relevant factors. This case is also nothing, my lord. This is just to, my lord, harass the petitioner, my lord. This is the case, my lord. And therefore, my lord, this is also one of the relevant factor, my lord, that may be taken into it. These two ground, my lord, basically my case rests on that one.
That bail petition original records, are they here? Bail petition original records. Click on bail petition number. What was that bail petition number? AB number 2355 of 2019. You have to record us in bail. Anyway. So your main ground is that the order does not reflect anywhere the reason for taking cognizance and the reason for issuing the summons, and the other one is that the charge sheet does not reveal.
My lord. Except, my lord, bare bald allegation, there is not a supporting materials, my lord, for how even if it proceed, how it can be, my lord, taken on its face value, even, my lord, conviction cannot be done, my lord, on the basis of this charge sheet, my lord.
Okay. Yes, sir.
Lordship.
Tell us.
Lordship, state is respondent number 1 if they have something to submit. I am
yes.
Number 2. State.
Your perhaps submissions would be only limited to page 84.
I will do it. কোনো অসুবিধা নেই। আমরা ঠিক নাম
You have the order dated 262023, which is impugned here.
Is number 84.
Does he have the records?
I will give him a brief. Let me appeal it. May have one.
Yes.
Lords,
Okay.
Lordship, I seek the indulgence of this court to kindly pardon and forgive me if any error is made inadvertently
We'll
while
try to
presenting
accommodate
my
you to
case
the
before
extent
this
possible.
court.
We'll
Lords,
accommodate you.
I need to answer to 3 points which he has raised before this court, before taking my submissions before this court. The third point needs to be addressed first before I address the other 2 points. He says, the petitioner, that I have lodged several FIRs against him, and that is one of the wrongs I have done. A stalwart like him making such a submission, Lordship, a person makes a complaint before the police. If it discloses a cognizable criminal offense, only then it is registered as an FIR. And then it is investigated. If the crime is established or prima facie established, it turns into a charge sheet. Then it goes to the table of the learned trial court, where the magistrate applies his mind that whether the investigation was correct, the crime was committed or not. And when each of my complaint has been registered as an FIR, each one has been charge sheeted against him, and he is facing cognizance order summons from each court. What face he has to argue before this court that I am making FIRs against him? Did I invite you to commit crimes? Are not you ashamed of committing crimes over here? Saying that I have lodged 4 FIRs, there will be 40 FIRs against you. What a criminal you are. How can you make such a submission in this court? All the FIRs have turned into charge sheets. It is shameful to make such an argument by this stalwart.
Mr. Agarwal, petitioner in person.
Lordship, I sought the indulgence.
No, you have asked us to accommodate you. We'll accommodate you so far as you maintain the dignity of this.
Lordship, I go down. But
no, you are what we had tried to convey to you on the last occasions also.
Lordship.
And what we are trying to convey today also.
Lordship.
Please stick to the
Lordship.
submissions on the case and do not go into an area where we would be loath to decide.
Lordship,
just stay to this point. Whatever you have submitted till now could have been summed up as I have lodged the FIRs. They have culminated in, I have lodged complaints. They have culminated in the FIRs. Charge sheets have been filed in each case, and therefore I was within my rights to do so.
Lordship,
it ends there. The rest of it is academic. The rest of it is a part of news. The rest of it is a part of a show. which we do not want in the court.
Lordship.
And therefore, the training for the lawyer. We have allowed you to appear in person. Do not make us think that perhaps a professional should be assisting you.
Lordship,
We want to hear you.
Lordship.
Stay limited.
I will try to, Lordship, and I will. Lordship, lies are sweeter and truth is bitter. That holds the ground over here.
We are not deciding the truthfulness of the
Lordship,
fire.
now the
We are
second
not
point which I need
anything
to,
else.
Lordship, he say the petitioner second point is that the order is a mechanical one without application of judicial mind. Now, Lordship, the cognizance order here is on page 84. It reads, case record is received from the learned CGM Kamrup Metro for disposal. Pursued the case record. I have placed one judgment of the Honorable Supreme Court, Pramila Devi versus State of Jharkhand. My lords can kindly come to page 4, para 14, 15, 16, sub para 14. And then my lords can come to page 6, para 8. May I read, Lordship? At the stage of cognizance and summoning, the magistrate is required to apply his judicial mind only with a view to take cognizance of the offence, to find out whether a prima facie case has been made out for summoning the accused person.
Which part you are reading?
Lordship, page 6.
Yes.
Para 8, Lordship.
Para 8,
At the stage of cognizance and summoning, the magistrate is required to apply his judicial mind only with a view to take cognizance of the offence and to find out whether a prima facie case has been made out for summoning the accused person. At this stage, the learned magistrate is not required to consider the defense version or materials or arguments, nor is he required to evaluate the merits of the materials or evidence of the complainant, because the magistrate must not undertake the exercise to find out at this stage whether the material would lead to conviction or not. I did not take much of a time, Lordship. The other paragraphs point towards the same. The summary is here. If the learned trial court says, I have pursued the case records, it has gone through. Who are you to dictate the court that it should write the judgment in this manner?
Again, a wrong line of argument. Who are you will not come in.
Lordship, I
just say that he has done it
Lordship.
and he has done it correctly.
Lordship.
Stop there.
Lordship.
Yes.
With 195, Lordship,
he has given up.
He has conceded. I have placed equal
We
sigma
are not
arrow.
convinced on the earlier date. We are not convinced today. Yes.
Now, Lordship, when we come to this court, this honorable constitutional courts, we are duty bound to approach these courts with clean hands. Doctrine of clean hands applies to all stages of judicial proceedings with full force. I had on the earlier date challenged this petition on the points of maintainability before we go into the facts, points of law and grounds of the case. I stated that the petitioner has approached this court suppressing facts, attaching fraudulent forged documents, playing fraud on this court, and playing fraud on this court is the utmost criminal contempt of this court. Article 215 of the Constitution says this honorable court is a court of records and derives its power from Article 215 to punish for its own contempt. What can be more contemptuous than fraud on court? My lords, I had taken my lord's attention to a few paragraphs over this petition, which is para 5.15.
Just a minute.
I would like to take my lords on page 13 of the petition.
Just a minute. 1.15.
5.15, para, page 13, lordship.
Page?
Page 13, lordship, of the petition.
5.15.
Yeah. The last three lines, lordship. This is with regard to Latasil case, lordship. Because the Dibrugarh case remains pending since last 8 years with no outcome to conclude in sight. It says it is pertinent to state that the petitioner was never summoned or interrogated by the police in connection with the said case during the investigation. Then I took my lords to the charge sheet. My lords, the charge
Just
sheet.
a minute.
Let us see this. Now, I took my lords to page 81 of the charge sheet.
Just a minute. Yes, page
Page 81.
81.
Yeah. Lordship. Sub point 22, Lordship. Lordship, it reads status of the accused. Not arrested on compliance of notice under section 41A CRPC. Then I took my lord's attention to page 81A. He says that I was never summoned or
Where
noticed.
do you say not arrested?
Lordship, page 80A.
80A.
Lordship, the first column, the last line, 22. Status of the accused not arrested on compliance.
Yes.
Then I take my lords to page 81A. Lordship, in 81A, the second paragraph, 1, 2, 3, 4, 5, the sixth line. Second paragraph, sixth line, Lordship. Specimen, handwriting and signature of Sri Taung Neri has been sent to DFS Assam Kahilipada, Gauhati 19 for examination and furnishing of opinion. Now, with this lordship, I presented before my lords that he says I was never noticed or summoned. The charge sheet says he was not arrested because 41A complied. 41A is a notice. And the body of the charge sheet says his handwriting and specimen were taken. On this, my lords asked him to bring it on record. Now, lordship, the affidavit points towards perjury. My lords can kindly take his affidavit that he has presented before this court, page 87, lordship.
Yes.
Lordship, the last 4 lines. Beg your pardon, Lordship. So, Lordship, the 4th paragraph, I am sorry.
Yes, we read it.
The deponent humbly said that he was summoned by the concerned police only on one occasion. Now, Lordship, this honorable constitutional court is not a laboratory to experiment with lies. Now, my lords can come to the petition, para 5.16. Lordship, he has attached a certified copy of the FIR, a certified copy of the orders of the trial court, but he has attached an uncertified copy of the charge sheet. Now, he says I was never summoned by the court. I brought it to my lord's notice. My lords asked him to bring it on record. Now, my lords, the affidavit points towards perjury as deeper as one can expect. Now, lordship can kindly come to page 88. The paragraph. May I read also? The deponent reiterates and affirms that he never received any summons from the court in connection with the aforesaid criminal case. The deponent engaged the advocate, Mr. Basumatari. Mr. Basumatari is here before my lords, to ascertain the status of the criminal case and to obtain the necessary documents for the purpose of filing the criminal petition seeking quashing of the impugned proceedings. It was only then through the advocate that the deponent came to know that the impugned order 2623 taking cognizance of the offence such as have been passed. Now, lordship, this is very vital. I have never seen such a fraud again. Certified copies of the impugned order dated 2623 and the FIR lodged by the private respondent were issued to deponent counsel on 3/4/24. My lords can kindly come to page 78. The FIR certified copy was issued on 19/1, not 3/2, 3/4. Page 78 is the copy, certified copy of the FIR issued on 19/1. And lordship, page 84 is the order on 3rd of April. Now he is saying both were issued on 3rd of April. Now the rest is, lordship, something which I never expect. However, it appears that the concerned court staff inadvertently omitted to certify the copies of the charge sheet. You did not apply for the charge sheet. He gave you graciously. He knew that you will be requiring a charge sheet, but he gave you an uncertified copy without applying. We roam about in the trial court.
How do you know about the non-application?
Lordship, he says, I applied for FIR and orders. He never says I applied for.
Where does it say?
Lordship, here it is. Certified copies of the impugned order dated 2623 and the FIR lodged by the private respondent were issued to deponent counsel 3423. It doesn't say that I applied for anything called charge sheet.
No, he doesn't say he applied for anything.
If my lords,
He doesn't
for
even
the
say that he applied
lordship,
for
I abide by. Let it be in that sense. Even if you applied, we roam about in the courts for certified copies. I have never come across any instance where an uncertified copy is issued. My lords have been before this court. My lords would not have even come across such a thing. Now, lordship, the last para. However, it appears that the concerned court staff inadvertently omitted to certify the copies of the charge sheet while furnishing the same. To the engaged local counsel. And the FSL report was also not furnished along with the charge sheet. Now the counsel is here. He can throw some light that whether he applied for a charge sheet and the FSL report and it was not given to him and an uncertified copy was given to him.
Okay.
Now, lordship, why I brought this to the notice of this court is very important. An ad interim injunction was taken on the trial court proceedings. A stay was granted on a pleading that there is no FSL report. There is an FSL report, lordship. I present with my lords. It says the original is not there, hence the FSL is silent. And that was the submission suppression of fact which led to an interim stay.
Where do you find that?
Lordship.
That in the absence of a FSL report, the stay was granted.
Lordship, it was a submission of the council when the matter was adjourned for verdict on 27/9/24.
27/9/24.
This case was adjourned for verdict. The verdict did not come up. And after 10 months and almost 9 days on my
No,
claim.
you said that the stay was granted. The stay was granted in the absence of a.
That was a submission in the court, sir, lordship. It is not recorded in the orders.
Okay.
Because they pleaded innocence on all counts. They said that neither an FSL is there, no investigation is there, I was not summoned. They had everything to their credit, lordship.
Okay, next.
Now, lordship, I raised my lord's attention to an agreement which is annexed here, which is the bone of contention, the entire case. Lordship can kindly grant me a minute. It's Lordship can kindly come to page 25 of the petition. Lordship. Page 25. Lordship, the top of the page 25 reads equipment rental agreement. So in a rental agreement, we don't have a lessor or a leasee. In a lease agreement, we have a lessor and a leasee. It has been my stand that the agreement was between my mother and the petitioner. And the petitioner's stand was that it is between him and me. Now, Lordships, we are antipoles. At no point of time, we say there were two agreements. I say it is with my mother, he says it is with me. So if I can prove that it is with my mother, his version goes. Or if he can prove, my version goes. Now, he has been attaching this particular document in all the proceedings. Now, my lords rightly asked that where is the original of this? My lords, I need further consideration in the matter. If my lords kindly come to page 23, the affidavit filed by him in the petition. Point number 3. That the annexed to the petition are true and correct copies of the respective originals. Now, Lordship, in the affidavit filed now, he says that after entering into this agreement, I took it away. The agreement is 2017. So in 17, he never knew that a case is going to come up in 24. And he got a certified copy in 24 for this. When the original is not before you, how a certified true copy is being produced? That means the affidavit is lying. Another case. It is not a copy of the original. No such document exists. Your affidavit is a false affidavit. How can you go along with this petition? My lords, in the particular agreement, point number 2. In this regard, the lessee has paid an advance amount of rupees 14 lakhs to the lessor. Lordship, this agreement is made on 20th of January 2017. And he has seen that he has already paid. Now, Lordship, in which Gregorian calendar does March come after January? In the next page, he has attached a certificate given by somebody that he received money on my behalf in the month of March. Your agreement says it's paid in January.
You have to come back again. What did you say?
Lordship, in this agreement, which I say is a forged one, point number 2.
It says that it has been paid.
Paid on 20th of January. So I asked for the details because 14 lakhs is no small sum of money. I have bank accounts. Now he came up with another fraud. Fraud par excellence. He attaches one certificate by an unknown person that I directed Mr. Petitioner to deposit the money into his account. Fine. Where is the letter of direction? No. On 20th of January, your agreement says you have paid. You have not used the word issued. I don't have a joint account with this person. So if a check is issued to me, it cannot be created into a third party's account. And in any Gregorian calendar, Lordship, March doesn't come after January.
No, in all calendars, March comes after.
But Lordship, I think my petitioner is having something else.
No. In every calendar, we find March after January.
Lordship, January comes first, March comes thereafter.
That is what.
So if he has paid an advance, it should be in January or before January. How can it be after January, Lordship? Now, when, Lordship, you come to this court with unclean hands, suppressing facts, attaching forged documents, frivolous statements, fraud on court, there are only 3 remedies to this court. Dismissal of the petition, imposition of exemplary costs, and initiation of contempt proceedings. This is the 18th time, Lordship, this case has come up. And I have calculated a summary as to how judicial time has been wasted. On 6 times, he did not have time to come. He sought adjournments. On 5 occasions, trial court records did not come from Kamrup Metro. They took 2.5 years to come. On 2 occasions, they were paucity of time. On only 4 occasions, the matter was heard. For 2.5 years, the trial court is not taking up my further investigation petition. Lordship will be surprised to see the IO of the case has been under FIR by SDGM2. And my further investigation petition could not be taken up because there is a stay. The stay died a natural death on 27/9 because the order never came up. And subsequently, when the matters came up, my lords never entered the area of allowing an interim stay. But in lines with the order of UP Bar Association, since a detailed order is required, vacating an interim stay, the learned trial court did not take it up, Lordship. Yes, that will be a problem.
They are not taking it up, is fine.
Because the trial court says we need a order specifying that the stay has been vacated. It has died a natural death. We are not interested. Now, Lordship, precious judicial time has been wasted. The trial is not starting. My petition for further investigation, nothing could be taken up because of this luxury petition. They have taken the judicial time to be charity. If his affidavit is taken on record, there cannot be any mercy to him. He is to be dealt with an iron hand. Lordship, I came across a Latin term. I don't know how to spell it, but still I will try. It reads fiat istutia ruet silam, which means justice has to be done though heavens fall. It not only should be seen to be done, it must be done with an iron hand to this petitioner. Now, Lordship, by an order dated 2/9/25, all the petitions were tagged together. But I don't know under which order the registry has segregated 6 and 7, because they should have been tagged together. In 7, Lordship, is an IA where I have prayed for vacating the stay. I prayed before also, but my lords allowed me to file an IA so that my prayer for further investigation can be taken up. Initiation of contempt proceedings against him. Initiation of a case by the registrar for crime under 195, the previous one, read with 340 CRPC. Suppression of FSL report. As mentioned, if my lords can kindly take up 1308, which is item number 7.
One three কিবা I এখন
1308, Lordship. Lordship, here in this petition, I challenge the maintainability of criminal petition 558, which is item number 6.
Criminal.
Lordship, my prayers are that there was a stay here on.
Yes, we've seen that. We read the prayers.
Lordship. Lordship, may I take my lord's attention to 2 more pages? My lords will be surprised to see if my lords come to page 103 of this IA 1308. Lordship, point number 9 and 10. The petitioner in the criminal petition pays police in black and white And that is the reason my Dibrugarh police is sleeping on the case for the last 8 years. Lordship, one more glaring thing I would like to bring to my Lord's notice. My Lords can kindly come to page 92. Because it's a fraud in and out, Lordship. Each page is a fraud. Lordship, the petitioner filed an FIR against me. I was arrested, tortured. That is a different course of action. An FIR was submitted. He filed a protest petition. The magistrate did not entertain. He went to the High Court without an affidavit as per Priyanka Srivastava. It was allowed. Even after further investigation, the second time the case against me has been closed as FR, and the crime branch has booked him under 182. I think I don't need to elaborate section 182 to the petitioner. And he has not challenged any of the FIRs. Just a bail, that one does, Lordship. Because once you have the bail, they get galloping dates of 6 months in those courts. So I don't think the trial will conclude in my lifetime, Lordship. Because there are many more remedies available to him. But since the fraud has been proved, contempt has been proved, I will pray to this court that such an iron hand should be used over him that he doesn't dare to do fraud in this court again, ever. My Lords can kindly come to page 92, Lordship. Lordship, in his petition, he says he spent a sum of 11,40,000 on repairing my excavators. And he has attached an invoice. Now, Lordship, I am not as smart and shrewd as he is. But on a plain reading, I read it is a pro forma bill. Is pro forma bill an invoice? I look like a fool, but not so fool. Lordship, how can the courts be cheated like this on oath, Lordship? Neither the name of the seller is there, neither the detail of the buyer is there, no tax paid, no money receipt, and you have been ranting and lamenting that I have paid 11,40,000. You come to this court hiding the facts under the carpet. It should be investigated whether it is a bill or not. And if it is not a bill, he should be fined exemplary, Lordship. He pays to the police 80,000 on record. He attaches pro forma invoices or invoices. What a mockery and abuse of power of Lordship. He files fraudulent complaints against me. He is charged under 182 IPC. A seasoned accused, I will not use the word criminal because, my lords, I have been very controlled in my submission. Lordship, I have been suffering this punishment for the last 8 years. I will just take 5 more minutes. My lords need to know the background of the case. What happened? In 2017-18, my mother is the owner of some excavators. She gave it to the petitioner on hire. The agreement was entered in Dibrugarh. He took the machines which were lying already in Arunachal, did not pay a penny. Whenever we used to approach him, he used to, as it happens in his own locality. Lordship, up to this, it is a civil case because payment of money is a civil case. My lords are not his money external. He sold off the excavators. My lords, excavators were seized from different persons under deed of sale. And when they were seized, he lodged a false FIR against me and got the excavator from the police station to his residence. In 8 years, none of the excavator has been seized. Each of his submissions in all the petitions are fraud. He says, I have submitted. Lordship, we have seen Olympics, the gymnastics. He is a better gymnast. In the petition, he says that I have delivered all the excavators to his caretaker. After a few lines, he says, they were seized by the police. After a few lines, he says, the caretaker seized it. My lord, Leo Tolstoy would have been ashamed at his fictions. What a fiction writer he is. I I have never seen, Lordship, such a gimmick being played in the court. We are fearful of writing even a small wrong. Nobody can dare because it is the temple of justice. He has made it a laboratory to experiment with lies. Now, I was arrested, tortured, everything done. The Arunachal Police DSP has been arrested. SI is facing trial. 48 persons are in the loop, Lordship. Half of them are Arunachal Police. And Dibrugarh case has nowhere to go. It will take another 10-20 years because enough money has been paid. If 80,000 is on record, how much zeros have gone below it? It is a case where 8 years are required, Lordship. Now, Lordship, coming to the forged document, which is the bone of contention here. When I raised this issue, the petitioner has been raising this 195, which was adequately addressed in the bail order, which is 799. It was laid to rest by this honorable court. Principles of res judicata comes in. When something has been settled, you cannot take it again and again. Now, Lordship, what if I am producing a certified copy? The original must be here because it is an exact replica of it. The original was never seized because when you give the original, the truth will come out. He never allows that. Lordship, my mother's agreement was seized by Arunachal Police, which he says I never entered into. My lords can kindly come to that part. By mistake, I left it out. The FSL report is there in my IA. I will just take my lords to that. My lords can kindly come to the Lordship indulgence kind. Have that report. I'm able to retract it, Lordship. It was here. No, it was straight. Lordship, the FSL report is on page 77, Lordship.
Of the IA.
Of the IA 1308, Lordship. Lordship, when he says that he never entered into an agreement with my mother, how does this FSL come up? And now he says FSL may be correct. There are other circumstances. He has not challenged this FSL. This
Page
is
70?
Page 121 of the IA, Lordship. His page is 77. I beg your pardon. Page 121, Lordship. IA 1308. Now, Lordship, this is an FSL report in the FIR lodged against me, where I submitted the agreement between the petitioner and my mother. And the FSL has found the agreement carrying his signature to be true. So, there was only one agreement which has been proved to be correct. He created a false document and he has run away with it.
Now tell us the doubts that we have.
Lordship.
The order dated 20.
16.
2/6/2023, my lord.
2/6/2023. Now, this says that on perusal of the case record, it appears that the charge sheet was submitted against the accused person alleging commission of offense. Issue summons. The judgment that you have given, have paragraph 15 for a moment. Paragraph 14 first.
Lordship.
Coming to the first issue, we have no hesitation to record that the approach of the High Court was totally erroneous. Perusal of the order taking cognizance discloses that the Additional Judicial Commissioner has stated that the case diary and case record have been perused. Same is the case here?
Lordship.
Which disclosed a prima facie case under sections 498A, so and so, against the accused, including the appellants.
Lordship.
Further, we find the approach of the so and so correct in as much as while taking cognizance, it firstly applies its mind to the materials before it to form an opinion whether any offense has been committed, and thereafter went into the aspect of identifying the persons who have committed the offense.
Lordship.
Accordingly, the process now moves to the next stage.
Lordship.
Coming to the order dated 2/6/2023, he has gone through the charge sheet and he has said that the charge sheet has alleged commission of offense.
Lordship.
He does not say anything further. Applied its mind to the materials before it to form an opinion as to whether any offense has been committed. That was the earlier judgment, the judgment that you have given. That we find missing here. Number one. Number two, if you come to your other paragraph, paragraph 7, paragraph that you read out, page 6, at the stage of cognizance and summoning, the magistrate is required to apply his judicial mind only with a view to take cognizance of the offense. Now here, if the magistrate, learned magistrate, had taken a view that forgery has been alleged, FSL report is there, that part has not come up. We think it should be tried. This one. Nothing is here. The charge sheet alleges so. Issue summons. Number one. Number two, you have said that you have made a prayer for further investigation in the matter.
Lordship.
The moment there has to be a further investigation, it is your submission that this investigation is not enough.
Lordship.
If this investigation was not enough, could cognizance have been taken? Perhaps not. Some more material was required. Therefore, taking of the cognizance at this stage it was done.
Lordship.
And in the manner it was done.
Lordship.
Is it correct? Your all other allegations, your all other arguments regarding the that he had taken away your vehicles, the police was involved, this happened, that, all these are not subject matter before here, but are only relevant to the court to try and understand what is the
background of the case.
Background of the laws.
Absolutely.
Otherwise, what this court has to now decide is the manner and on the materials available before it. Was the trial court correct in taking cognizance at that stage? Two things are going against you.
Lordship.
One, it is only the charge sheet which was taken into account, that it levels allegations against the accused, and two, your own act of asking for a further investigation,
Lordship.
prompting this court to believe that it was not the stage where the learned magistrate could have taken cognizance.
Lordship. My lord.
So even if this order is found to be not correct in its present form,
Lordship.
Nothing would stop the magistrate from taking a cognizance, following the law,
Lordship.
giving his reasons to whatever extent possible, and on materials which are sufficient to take a cognizance.
Absolutely, Lordship.
Now, if this cognizance and this summons has to continue, if this is the cognizance order, your prayer for a further investigation contradicts it.
But my lords, to my limited knowledge,
Because once the trial starts, the cognizance has been taken. Can there be a further investigation?
Lordship, there can be.
There can be, provided the situation is such where the trial court deems it fit that no, there may be something more or there is something missing.
Lordship.
Let us go ahead. But with what was available and your request to have a further investigation,
Lordship.
cognizance at this stage.
Absolutely agree, Lordship. What happened? We were not allowed a chance to present our further investigation petition because in the meantime a stay came up. So we were left in the doldrums, neither here nor there.
We understand. The thing is, what happens to a case is beyond this court because that is for the trial to take
Absolutely,
place.
Lordship.
What we can sit here and do is try to find out whether the law is being correctly followed so that once the trial ends, it does not have to go for a retrial again because there was some lapse somewhere in the decision-making process, right?
If my lords allow me, I will like to make a small submission. Lordship, in my submissions, I said that we have to test this petition on the touchstone of maintainability.
That is for him to understand. Therefore, I told you that these are the issues which I am placing to you,
Lordship.
to answer.
Lordship.
The issues that
my lords are
the issues that you have put to us, or you have raised against him, saying that yes, there was a falsity in the affidavit, there is a wrong submission in the petition. It is for him to answer. We'll come back to him.
Lordship.
Whether the petition is at all maintainable or not.
Lordship.
Assuming for the time being that it is maintainable.
Lordship.
Whether this order shows some reason why he took cognizance, which can be called a reason in law. Secondly, if there is a necessity of further investigation, whether cognizance at that stage in the manner done was.
Lordship, I will humbly answer it in two different ways. There is a necessity for further investigation because the fraudulent original copy has never been seized. It is needed, although I have presented that my mother's agreement is true, everything, but his anticipatory bail was not cancelled because there is no FSL report. He has attached a certified copy stating it is an original. So this affidavit goes. He cannot say two different things, hot and cold, both at the same time. He has to produce the original. He is duty bound to bring it from where you can. Nobody will going to listen to you. Coming to the cognizance part, with deep faith in this court, my lords can take any decision in this part. As far as further investigation, it is must, and my lords can kindly bind the petitioner to bring the agreement before this court. This court has the power to get it examined before itself.
The moment he puts up an affidavit saying that, look, sir, the original is with you, and you say there is nothing on record. I have never signed such a thing. That becomes a question of.
My lords, there is one more fine point to it.
That becomes a question of evidence and.
Lordship, here it comes. I am not a man of law. I am very simple man.
That is why you would perhaps see that we are trying to show.
Lordship have been kind enough to me.
What?
My lords, when in his criminal petition at the stage of filing, he says this is a true copy of the original. That means the original was before him when it was certified. Today he says that in 17 it has gone. You are filing a petition 24. How can I agree to it?
It is not always a case that when I am signing it, the moment I am signing it, the original has to be before me.
Lordship,
that is the difference between an attestation and a certification.
Lordship, I have
certified that this boy has been a student of this college for the last 3 years. The principal might have come yesterday, but he certifies it.
Lordship, Lordship, I have applied for certified copies from this court. What I see, the department takes out the original, makes a copy of it, verifies it word to word, comma to comma. Even if some print has gone missing, they throw it out.
Let us not go into that aspect of the matter, that a certified copy was actually handed over to him or not, because that will have another inquiry. We can start that inquiry without having a reference to this case, without having any effect on this case. But then there is again a saying called to err is human and coincidence. So we would not like to go into all those arguments, allowing the learned counsel for the petitioner or you to have a war of words. What we are trying to find out here in this petition is simple.
Lordship.
Your argument, whether the petition is maintainable at all. If not, everything goes.
Lordship.
His argument that since the order does not reflect any reason as required in law, this order is not. An order taking cognizance, giving reasons, asking me to appear, yes, could be correct. And then therefore the Supreme Court also says in this case that once he receives a summon, he can go back and he can say, discharge me. That option comes to him then. So whether this order taking cognizance and summoning you is correct or not, that is what we have to restrict ourselves to in this case. Even if this order is wrong, is a correct procedure prohibited in law? Definitely not. Absolutely. So that is the whole crux. That is why we have taken up this matter for disposal without reference to your IA. If we decide that this order is correct, everything else goes here. If I decide this order is wrong, then it is a wrong done by the
trial court.
And everything that you have taken up here, including the false affidavit, are all matters which will come before them. Therefore, I need not again go into that. Yes, Mr. Bushta, what do you say?
Lots of controversy from both sides.
We will leave out our controversy.
Regarding that, if at this stage, if he is seeking for further investigation, if at this stage that cognizance order, that cognizance order, demand back the trial court, and to considering his petition for further investigation, then I think it will be sufficient, because to consider that total trial court will decide whether his petition.
Because in this order 26202, what is haunting us is
for considering his
2620, where it is haunting us is,
yes,
it says charge sheet is there. No, charge sheet is there, alleging commission, therefore summon. Cannot happen like that. Perhaps.
Yes, details is not there.
Had it been, yes, charge sheet, due investigation, this done, I think.
Yes.
There may be an option of a commission of that offense, therefore summon. Then he has the option of a discharge. But because there is a charge sheet, therefore I summon,
straight away.
That may not be correct in law is what is haunting us.
Straight away.
Lordship, if at all I succeed on the maintainability point, and the
what he will
petition is dismissed, even then the magistrate can take up my plea for further investigation because there is no stay. And even Lordship decides anyway, my lords will be kind enough to kindly allow my prayer for further investigation.
No, that we cannot allow. That will be upon the trial court to see whether your application for further investigation requires to be allowed.
Yes.
Whether there is something in the charge. Otherwise, we'll be taking up their role.
No, Lord cannot do. I am apologizing.
Because
I meant to say the vacating of the stay, because then the court can try.
Have you seen this 2025 judgment that he has placed before us? I don't know how you can.
I will try to get it, Lordship.
2025 SCC online, Supreme Court 208.
Lordship, I will try to.
GM Laboratories. Now here what the Supreme Court has said is this. Here it says, summoning of an accused in a criminal case is a serious matter. It is not that the complainant has to bring only 2 witnesses to support his allegations, so and so. Order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegations made in the complaint and the evidence, both oral and documentary, in support thereof, and so and so. Thereafter, the order of issuance of process is not an empty formality. Magistrate is required to apply his mind as to whether sufficient ground for proceeding exists in the case or not. The formation of such an opinion is required to be stated in the order itself. The order is liable to be set aside if no reasons are given therein while coming to the conclusion that there is a prima facie case against the accused. The charge sheet reveals prima facie allegations, prima facie case against the accused, and therefore the summon would have done.
Lordship.
But here there is a charge sheet, issue summon. It is too routine, too mandated, too mundane a thing to do.
Mechanical. Lordship.
And in the end, in this case, the order has been simply set aside without remanding it back to the trial court.
Lordship.
So this is where his citation stands.
Lordship.
And in your citation, we have already told you,
Lordship.
the simple expression would also have done. But there has to be an expression, which we are at this point of time finding missing in this one.
Absolutely, Lordship. It's there.
Yes, Mr. Sonar.
My lord, my lord,
Kindly tell us in your petition
my lord,
at para 5.15,
my lord, my lord.
how did that mistake creep
My
in,
lord.
or was it deliberate?
No, my lord, it's not deliberate, my lord. Otherwise, my lord, this subsequent clarification at this, my lord, my lord, subsequently, that's why, my lord, it has been after due proper instruction, my lord, has been brought on record once he was called, my lord. So at the time of, my lord, at time, maybe, my lord, communication, there must be some gap in the communication. It was not deliberate because this is not going to help the merit of the case in any way, my lord. My case is only like, my lord.
A person who says that I do not have this copy and that copy.
My,
A person who says that I did not know of the existence of the case. I was never summoned there. I did not know about anything. And then in a halabu, I asked my advocate, what is happening in that case? And then he tells me, these are the papers. When he says that I never knew about the case, I was never summoned.
may I submit, my lord?
It's at the root.
May I submit, my lord? This is what happened, my lord, because, my lord, this one petition was moved by the respondent, my lord, for cancellation of my anticipatory bail, my lord, initially. So during that proceeding only, my lord, came to know about that about this case, and my lord, and we wanted to know, since FIR was there, my lord, against me, my lord, and their allegation was made that in connection that was the false FIR. That's why, my lord, to know the status of this particular FIR, my lord, yes, exactly. What is the outcome of the investigation, my lord? That's why that inquiry was made, my lord. It is not something, my lord, we received the summon and we went there and we knew it, the case. No, my lord. Otherwise, my lord, what the benefit I would get, my lord, just making the statement, my lord, I did not receive someone, my lord, because this is not at all going to help my case at all, my lord.
Now,
had I received, my lord, I would have.
Now the second part of what he had said is, there is one set of vehicles. There is one set of vehicles which was involved in the entire fiasco. 2, 3, 10 vehicles taken at a time or taken at different point of time.
4 vehicles, my lord. It's something like that, my lord. Already his 4 vehicles were engaged in that part. So it was taken on lease, these 4 vehicles.
Now these 4 vehicles were taken by a single lease.
My lord, my lord.
He says the lease is with the mother.
Here is the disputed question of fact.
You say the lease is with him. Yes?
No, my lord. Here is the problem, my lord.
Please.
Now, what he is saying, my lord, that this is not the lease agreement where he executed, my lord. Now, my case is that my case is that this is the lease agreement. I have never met his mother till date, my lord.
Now we stop here. Now we stop here for a moment.
My lord.
The FSL report produced by him in the other case or somewhere, it says that the signatures on the lease agreement with the mother are yours.
my lord, very interesting, my lord. That part, my lord, that case, my lord, they, and very interesting it will be happening, my lord. In that case, my lord, even the mother was not even called for investigation, my lord. That's why, my lord,
True.
I
True.
filed the application for further investigation.
That FSL report, is it in issue in any case?
My lord, that was the case, my lord, where I lodged the FIR against him, saying that, my lord, he manufactured a false lease agreement on the name of his mother, my lord.
And where your signatures were present?
Yes, my lord. And I have alleged that in that agreement, I have never signed and I have never met his mother till date, my lord. Till date, I have not seen his mother, my lord.
You are not answering my question.
My lord, my lord.
My question is, when the forensic laboratory says that the signatures on the lease agreement with his mother are yours,
My lord.
have you disputed that forensic laboratory report anywhere?
That's why, my lord, I filed the further investigation because on that basis, closure report was filed by the police, my lord. So I challenge that closure report.
Oh, no. We are saying that, again, my question, the FSL report which contains your signature
My lord.
and is said to be correct in the lease
my lord, that's
executed with the mother.
My lord, that was disputed, my lord. That was disputed, and in further investigation, application was filed, my lord, and that was allowed, my lord. We disputed, my lord.
Then what happened?
Then, my lord, I have no instruction after that what happened, whether further investigation charges has been filed or not, my lord. I don't know. But it's sure, my lord, that when the closure report was filed by the police against the respondent number 2, my lord, saying that this was not forged, my lord, then immediately, my lord, thereafter, I challenged that closure report by filing the application, further investigation, saying that this whole investigation has not been properly done. It's the same investigation, the bias investigation, and therefore, my lord, considering the plea, my lord, the order was passed for further investigation, my lord.
Okay. And this statement, it is pertinent to that never interrogated by police. You say this is an inadvertent mistake.
My lord, inverted, my lord. Otherwise, my lord, I have not have got any benefit by making this statement. my
Now,
lord.
someone has certified this equipment rental control.
My lord. This was in
Is it not?
the anticipatory bail application, my lord.
No. In the present petition, it has been certified by someone.
My lord, my lord, my lord.
Without a reference to the original.
My lord, sometime, my lord, every time we don't have the original document with us, my
But
lord.
that statement did not come up in the petition anywhere.
My lord, that part is there, my lord.
If it has not come up in the petition anywhere.
My lord. My lord, petition, it is not there, my lord. But once my lord has put to the question, my lord, I have brought on record, my lord, that this particular document, my lord, original is with the respondent, my lord. So, my lord, here is the case. So many disputed question of fact are involved, my lord. And my lord will see, my lord. Otherwise, my lord knows, my lord, scope of 482. Of course, those disputed question of my lord, I have enclosed now. So many to show, my lord, even bank statement, all those things, my lord, in this Agarwal statement, my lord, he has received 14 lakhs, and this is supported by the bank
But have you
transaction
seen,
also, my lord.
have you not seen that when on the agreement of 20th of January 2017,
My lord, my lord.
he acknowledged, both of you agree that already the amount has been paid.
Yes, my lord. That is there.
At page 27,
yes,
the amount comes to be paid in March.
On, my lord, no, 2 times, my lord. On 24/1/2017, 8 lakhs. And
So it was
7/3, 6 lakhs.
14 lakhs were not paid.
My lord, as per the subsequent record, my lord, not at that exactly time, my lord. That is there, my lord. That is on the record. But on 24, my lord, 8 lakhs was paid.
We are putting these questions to you only because we have to decide on the maintainability of the petition.
My lord, my lord.
Even if we hold the petition to be maintainable, and the order of the learned trial court, even if we find it not to be in sufficient compliance with law, the matter is simply that there would be the liberty That order goes and the trial court would take a fresh look at the matter.
Well, here, my lord,
Nothing more.
apart from my lord, goes my lord, apart from this impugn order, my lord,
Hmm.
this another my lord will see, my lord has seen on the record charge sheet, my lord. My lord, is there any prima facie case, my lord?
Charge sheet, we are not interfering. Charge sheet, whether the charge sheet has some material or not, that you would approach and pray for a discharge or whatever you want to. We
But
will
my lord
not.
has a so
We
far,
will
my
not
lord has
influence. Nah, we will not influence the trial court to that extent. Sorry.
my lord has a power 482, my lord.
I may have the power, but I have the discretion to use it.
My lord, my lord. But
Huh?
my lord, I understand. Here is the case, my lord, where my lord,
We
as on
will.
today,
This is not a case where this court is convinced that we should be appreciating the charge sheet. We think that should be left to the discretion of the trial court.
my lord, as made him fit, my
Not
lord.
not beyond that. That is only in case we find the petition to be maintainable.
My lord,
And
my
in
lord,
case we find the petition not to be maintainable, it will be upon you to go and pray for a discharge or whatever there.
my lord, that is there.
And if we find the petition to be maintainable, and further if we find that this order is not in accordance with law, then we would just remand it back to the trial court to have a fresh look in the matter
That is
by
there.
setting aside this part of the order.
So
In
far,
the
my lord,
absence-
yes, my lord. So
Okay.
far, yes, my lord. So for maintainability, my lord, 482, my lord, this honorable court has a power, my lord. So far,
No, not on that part of the maintainability. The maintainability issue that he has taken up, saying that yes, there are false statements before this
my lord,
court.
my lord, my lord.
Yes, annexures have been signed without ever even seeing the true copies thereof,
My lord.
so on and so forth. And since these are not correct statements made before the court may not like to entertain the revision petition.
My lord. But my submission on that point, my lord. Basically, my lord, every wrong or my lord, not deliberate false statement, my lord, in the petition, my lord, that doesn't entail that summary, my lord, dismissal of the petition also, my lord. The issue is, my lord, whether
We will consider your submission that the that particular sentence in paragraph 5.15, if I'm not wrong,
my lord,
was an inadvertent mistake.
Inadvertent, my lord.
And can it be taken up to be an inadvertent mistake? And if not,
my lord, then, my lord, because
would it have the potential of guiding us to dismiss the petition?
my lord,
We'll
the
take all that
most important relevant factor, my lord, that whether such statement false or something, it has anything to do with the merit of the case also, my lord. This is also important, my lord. Because is by making this statement, am I trying to get some benefits from the court, or if I trying to, my lord, because it's nothing, my case is not at that point, my lord. My case is simply, my lord, that no prima facie case, mechanical issuance of this order, my lord, and so far I have considered so far, my lord, first point bar 195, my lord.
Since you
Therefore,
have given up the 195 point, and
my lord,
since we are not even discussing 195 in the judgment,
so my lord, that's why, my lord,
we will not write pages on what has been conceded.
my lord, my humble submission, my lord, this even if it is a false, it is a wrong, my lord, wrong statement, my lord, I'll say, but not deliberate, not touching the merit of the case, my lord. In that situation, my lord, that adverse consequence, my lord, that may not be imposed. Otherwise, my lord, can see the intention is not to, my lord, reap any benefits, my lord. It is not, my lord, every statement, sometimes it happens, my lord, because inadvertently, if it is met, the intention is, my lord, that delivery attempt and to obtain some benefits from the court, my lord, by suppressing the fact.
So all the other judgments that you had given to us on the earlier occasion, all of them, I think we can brush aside.
No, my lord, only 195, my lord, otherwise this one and my lord, subsequent it's saying judgment, my lord, the prima facie case in case of forgery, my lord, when the official report is negative.
Which is that case? Tell us.
My lord, will may I put, my lord, that my lord, 2024 11 SCC 733.
2024
11 SCC.
Just a minute. Mariam Faishuddin.
My lord, my lord.
Fasiuddin, yes. What does it say?
32, 33, and 34. 42, my lord. 32, 33, and 42.
32, 33.
32, 33, and 42, my lord.
Okay.
Similar nature of allegation, no FSL quashed, my lord. No corroborating evidence, only mere statement will not suffice, my lord, to convict. Even if it takes for face value, the allegation is there, my lord. Itself is not
And
sufficient.
these are the two judgments on your behalf that we need to consider. Yes?
My
Anything
lord,
more?
otherwise, my lord has a power to quash charge sheet, all
Oh,
those
that-
things, my lord.
Oh, that will.
Because, my lord,
Those judgments are to be referred to only to be referred to, nothing else. They don't need any elaboration from us.
my lord, my lord.
Minds greater than ours have done it already.
My lord.
So what is this, Sandeep Barodia?
Lordship, on the earlier occasion,
Ah.
I had showed a order of the coordinate bench where a part of the records were suppressed while applying for anticipatory bail, and this honorable court was pleased to direct an inquiry. Similar situation arises here. Because that is a crime under 466 IPC. Now, Lordship, the second point, whether the petitioner knows the case against me has been closed or charge sheeted. This court has the jurisdiction over Arunachal Pradesh. The records of that court can also be called for to satisfy this court. Lordship, just one last submission. Page 143 of my IA 1308. The last submission. I think that will clear the air over everything.
Yes. Yes.
Page 143, para 7. I read it, Lordship. It is a protest petition filed by the petitioner against me when the FIR lodged by him against me was closed as FR. What he writes, Lordship. That it is humbly submitted that the petitioner had agreed for the withdrawal of his protest petition on the basis of legal advice of his earlier counsel that in view of the FSL regarding the forged signature, it would be futile to pursue the case. Later, the petitioner, after having discussed the matter with other counsel, came to know that the expert opinion about the forged handwriting is not conclusive and binding upon the court, and the court can always come to a different conclusion on the basis of other materials and evidence. So he is leaving his own arguments in thin water, Lordship, that there is a forgery by me. When the agreement with my mother is found to be true, he says it may be true. There are other evidences. This is his withdrawal protest petition, Lordship, when the case is closed against me. He files a protest petition, withdraws it. After the crime branch accuses him of 182, he files a further protest petition. Now, this is the withdrawal of the first protest petition, Lordship. He says FSL rightly, but other evidences. So you have left your own arguments halfway.
No, but page 149, he says that reopen the case.
Lordship, what he says here.
What happened after this?
Lordship, the case was further investigated and again closed as FR. Nothing against me. And he knows well. The hide and seek has been going on for years together. You cannot say he doesn't know. He knows everything else.
Answer us.
Lordship.
Have you given that order of the trial court closing it again?
Lordship, I have applied. I had applied.
When was it closed approximately?
Lordship, 2-3 months back. And now he has been charged under 182, Lordship, for filing a false case against me. I have that order, if my lords can allow me. I have the anticipatory bail applied by him in that case. I have that order.
Since it is not a part of the record here, we will be catching him off guard if we take that on record. If we take those
Lordship,
facts
I just
into account, I'll be catching him off guard, not done in the court.
My lord, I have so many things to say, but since my lord 482, my lord is dealing 482 application, my lord, during that trial, we will bring out on the record what is there, my lord. And only my lord knows law that only forensic, on the basis of forensic report only.
We trust Mr. Sona to give the best fight possible for his client.
My lord, my lord.
Anyway. The contempt আছে next we got We'll have it listed on the 5th of May for delivery of orders.
The criminal petition, Lordship.
The criminal petition and the fate of the criminal petition will decide what happens to the IA.
Now, Lordship, there is one IA 195.
What is it?
The
What is
other
it?
respondents has submitted that he has already passed off, for which it was asked to be verified.
No, do you have that?
Lordship, I have a humble submission to make in that case. That particular respondent,
who
Mr. Manoj Kumar Bora, he is a co-accomplice of this petition. He sold the machines and he was running my machines. All his anticipatory bills have been cancelled by this honorable court, and he is under warrants from Incheon, Kamrup Metro, everywhere. He has not appeared anywhere, and being a cloudful man, the police is not touching him. Now he has come up with a death certificate. I do not have any objection. I have a simple thing which has come to my knowledge. He is also the owner of a nursing home, Lordship. What has possibly been done to deceive, Lordship? A dying man was admitted as Manoj Kumar Bora. He died and Manoj Kumar Bora was issued the death certificate. That is what possibly has come into my ears. Because he is under warrants from numerous court, Lordship. Every anticipatory bill has been cancelled.
If he owns a nursing home, would he have his own death certificate?
Lordship, nothing is impossible. Who will take the responsibility tomorrow if he surfaces on the Burma border, Lordship? I have heard it is on Panchu Pass he's roaming about. Possibly. I did not get a photograph of his. Even a doctor is accompanying him. His nursing home, Lordship, everything wrong is done in this world. So he got a dying man admitted as Manoj Kumar Bora. He died, a genuine certificate issued. But whether the dead person is Manoj Bora or not, nobody can take responsibility.
We'll have to exhume. No, we cannot. It's all
Lordship, kindly fix that matter after a few days. I may have the photograph of his, possibly.
But Malak, as per the last order, that report inadvertently, Malak, this was not sent. Today, Malak, there is a QR code. I have checked. Because it is mentioned in the death certificate that the QR code can be used for authenticity verification. I have checked, and it has come through Google Malak that downtown hospital he died. Everything, Malak, it has come. Here is the QR code is the death certificate.
Absolutely agreed.
Regarding the
Any father's name, mother's name, something?
that is there.
No, in the certificate.
Yes.
His father is late Kosheshwar Bora, Lordship.
Name is there.
I get it from the course title. I will
in the certificate it is there.
I'm not having a copy of it, Lordship. Kosheshwar Bora must. Now, Lordship, whether the man who died was Manoj Bora or not is a big question.
Again, not for this court to go into.
Lordship, kindly adjourn that matter for 2 weeks.
It is. All these matters will come up together. Today is the 21st.
Lordship, kindly give me a month in that case, 195, Lordship.
If the main petition goes.
No, it is not attached with that petition, Criminal 558.
This is attached with what?
Lordship, there was a cancellation of.
There has to be an IA. You are talking about an IA.
Lordship, Lordship, this is not in that criminal petition. I place it before this court. It is not related to what we have.
This IA is separate. IA is along with in AB 3239 2019.
IA number so and so, which is found tagged with the records. It record আছে না?
আছে.
Post list আছে নাকি এখন IA নামটো?
Item number 7.
IA 195 of 2025.
Lordship, it's a different case.
This is an IA in
AB 3239, Lordship.
AB 3239, है ना?
Lordship.
Learned counsel for the petitioner. In item 7 you take down, huh? Item 6 we have fixed for 6th. Or what? 5th of May. In item 7 take down, detect this matter from criminal petition number 558 of 2024. The learned counsel for the petitioner has submitted that this IA criminal has been filed in AB number 323. AB number 323. 39 of 2019. Full stop. Accordingly, list this IA along with AB number 3239 of 2019 within bracket disposed of on. You want 1 month?
Lordship, it will be very helpful.
We'll have it on 28th of May.
Lordship, any day.
On 28th of May.
Lordship, I beg my Lord's indulgence if any inherent error has been caused, please, Lordship.
See, that is why the professional training. where to hold your reins and where to let the horses run.
Absolutely, Lordship. But, Lordship, I will humbly submit that coming to courts is not a matter of pride and joy. It is to seek justice. And when such rampant frauds are being played,
We would be very happy when coming to court should become a matter of pride and joy because everybody gets justice.
And Lordship,
let that day come. We all hope that day will come.
Lordship,
But then we have our own procedural bounds and everything.
like this.
Otherwise, the attempt is always to entertain. Yes, Mr. Sona, thank you.
Deeply obliged.
On 16th, yes, 5th. It has.
Item 53 minutes.
Yes.
My lords, in item 53, I am for the petitioner in this matter. My suspension of sentence is pending, my lords. They have not filed any counter. It's been 6 dates now.
What was the offense?
My lords, this is NDPS, my lords.
Along with item 54, no? In 54, this filing. But it is along with item number 54. Perhaps in 54, objection has been filed by our colleague, Mala, B. Sharma.
No, there are two appellants.
Two numbers.
Two appellants in one case. Is
My
it?
Lord, yes, my lord. In my lord, both are my lord, there's the arising out of the
Both
same
were
judgment.
convicted by the same judgment? There
Yes,
are
my
two
lord.
appeals pending?
Two appeals are
In
pending.
one, you have given an objection
Yes, my lord.
to the prayer for suspension. In the other, you have not.
Yes, my lord.
We allow the other one.
Yes, my lord.
We will allow this one. No objection.
No,
You
my
have
lord.
filed in one. What about the other?
No, my lord.
You do
Yes, my
not.
lords. In 53, they have not filed from past 6 days, my lords.
My lord,
Yes.
yes, my lord. In
And my lords,
53,
my lords,
my
he
lord,
has undergone more than 3 years now.
NDPS commercial quantity, my lord.
Oh.
That is, my lord, my lord, 10 years of my lord, my lord, that is the convictions, my lord. That is the punishment for 10 years, my lord. So because
What
of
is
that,
the ground of appeal? What is your ground of appeal?
My lords, there are several grounds, including that 42
The strongest
is
one.
non-compliant.
Give us the strongest one.
My lords, 42 is non-compliant, my lords.
Or my lord, may I make one, my lord, submission before your lordship? Yes, my lord. Because, my lord, this matter is, my lord, there's a criminal appeal of, my lord, 24, my lord. Both are, my lord, 24. If my lord will go for the, my lord, that is suspension part, or my lord may fix both the matter for, my lord, that is the final hearing.
It is for final hearing. Last time we could not take it up because there was paucity of time. Is it not? This is item number
53, my lords.
53 is
Rakesh Chandramal Das, my lords.
Oh, finally.
it's in the hearing.
My lord, then in the hearing, my lord, without having, my lord, that is the, my lord, the file we can, my lord, proceed, my lord. Or otherwise give us some time, my lord. In the meantime, my lord, for the suspension
filing
part,
of filing of objections, whatever you need to do. This man is behind bars. We need to say whether he remains behind bars or he goes home.
my lord.
Is it not?
Yes, my lord.
এখন ক'ত? এখন আয়ে নেকি? আইখন আছে নেকি? Even the আয়ে.
Two numbers of IA in this petition they have filed, my lord. One is, my lord, that is the IA 968/2024. That is for the suspension of the sentence, my lord.
Okay.
Yes, my lords.
And another one, my lord, IA is there, my lord, that is 970/2024. That IA is, my lord, meant for, my lord, they are, my lord, that is praying for, my lord, this is the medical, my lord, that is a relief and all, my lord.
This IA 1970 we can consider and dispose today.
Yes, my lords. My lords, if they are arguing today, my lords, the arguing council is trying to join online, but
No,
courtmaster.
I think the Leonard PP is asking for some time to have it fixed on another date for a full hearing.
But if I may submit, Malaj.
Yes.
This has been their submission since September 2025.
No, on the last occasion, that was not their submission. It was paucity of time.
Malaj, no, Malaj, that they need time. First, Malaj, they said on first 5 hearings that, Malaj, that there is the counter has to be filed in this matter. Because, Malaj, previous, Malaj, your lordship predecessor had the view that because it's a conviction of 10 years, so, Malaj, counter is necessary to be filed for the suspension of sentence, Malaj, to be They've still not filed it, my lords. It's since September 25, my lords. Till date, the counter has not been filed, my lords. So, my lords, if my lords is giving them time, my lords, then my lords, either my lords, this be a last opportunity for them to file the counter, or they're dispensing with their right to file a counter, my lords, because my lords, then we'll accordingly, my lords, proceed with the arguments. There is non-compliance of section 42, my lords. There is also absolute non-compliance of the rules of the NDPS Act, which and how sampling has to be done. my lords.
Then, my lord,
In which case are you taking time from September?
My lords, in this case, Rakesh Chandra Mal, my lords.
I do not find any such order here.
Yes,
That is
my
why.
lords, in fact, my lords, that show, my lords, on every day, this has been their submission, my lords, that we have to, though not recorded explicitly, my lords, but that's the reason why the matter could not proceed. That the counter has not been filed. We are ready, my lords, we have a compilation also, if your lordship permits, we'll start the arguments right now, my lords.
Okay, my son, Rakesh.
I agree totally.
Records are showing that from on December, a mention was made. TCR, they wanted some time to go to the TCR.
My lords, they request for time to go through TCR, this 3rd December's order, my lords. First, they say that, my lord, TCR is not with them. Then, my lords,
Yes.
my lord, then as because my lord, it is now, my
Give
lord,
us a
fixed in the hearing column, my lord.
Give us a date. It is already in the hearing column because we.
Yes, my lord.
we had
Then, my lord,
that the disposal would be better than.
yes, my lord. Then, my lord, it can be proceeded, my lord.
Suspension than having it listed after so many years.
today also has been
My lord,
listed
then,
for
my lord, as because, my lord, it is in the hearing column, my lord. It is posted in the hearing column, my lord. The hearing of the, my lord, criminal appeal may be, my lord, taken, my lord. So we will make our submission, my lord. If my lord,
Give us a
we
convenient
will
date,
file our written argument, my lord, in this regard, my lord.
Give us a convenient date to you.
But it's as per lordship's convenience.
Yeah, and either between 4th to 8th of May or 11th to 15th of May.
But it's as per your lordship's convenience. I mean, Lord, my lords.
We can go for hearing, my lord. Any date, my lord, may be fixed, my lord.
But we'll file written submissions, my lords, for the appellants, my lords, and we can proceed with the arguments.
12th of May.
12th of May.
With or without your objections.
Yes. In the meantime, my lord, in the meantime, my lord, we will file the same, and my lord, it may be fixed for, my lord, hearing itself, my lord, for the main appeal. My lord. As because, my lord, this is for pending for 24. We'll go by that.
You are Miss Ashima Malla.
Please, Miss.
Do we need to record your colleague's name?
No, my lord, that may not be necessary. My lords, in fact, I'm entering appearance in the connected matters. Also, my wakalatnama, my lords, will be filed in the connected
Miss
matters.
Ashima Malla, learned counsel appearing for the applicant in this IA and also for the appellants in the appeal. The learned APP has sought for some time to file their objections in IA criminal number 968 of 2024. Full stop. This matter was listed today in the hearing column with an expectation that the matter can be taken up for final disposal. The appeal can be taken up for final disposal, but in the absence of the objections, the IA could not be taken up today.
Final well, that will fix the final
APP
hearing
has,
along with the criminal appeal.
APP has prayed that the matter may be taken up on the 12th of May.
12th of May.
By which time the objections to the interrogatory applications shall also be brought on record and an attempt would be made to finally hear the matter since the trial court records have also been received.
Master.
You want any orders to be passed in IA criminal 970 of 2024 where you are asking for some medical aid to the
No, my lords, because my lords, we are, my lords, pressing for the suspension of sentence, my lords, now on, my lords, the legal.
No, I think there is some plate in his right leg which needs to be removed.
Please, my lords, but my lords, into that effect only, my lords, we had requested my lords the state to verify this. So my lords, either my lords, they file a status report to this effect that my lords.
My lord, that report is not there.
Then you write and in I criminal number 970 of 2024, a prayer had been made by the applicant that appropriate medical attention may be provided to him regarding the removal of the plate on his right leg. Stop the learned APP shall also have instructions as to whether appropriate medical aid has been granted to the petitioner in that regard.
A copy of the order may be provided so that my lord, it can be sent to the my lord, that is the superintendent of the jail authority.
Printouts don't do.
And that we
no
do.
certificate. Copy of the order may be provided to the learned APP Mr. Boisha to do the needful to forward this order to the jail authorities. We'll have it on 12th of May.
I'm so grateful, my lords. As permission, my lords, maybe given to us, my lords, to file written synopsis, my lords, for my lords.
Parties would be at liberty to file their written synopsis before the next date fixed.
Please, my lords, I'm so grateful, my lords.
55.
7 years.
My pleasure. Whether the appellant is convicted for 5 years under section 366 of IPC. And my lord, 7 years for 376 subsection 1 of IPC. And my lord, already my lord, 1 year, 11 months after the pronounced judgment, he is in jail. And initially he was 3 months. So already more than 2 years he completed in jail, my lord. My lord, FIR space.
What about the respondent number 2?
Respondent number 2 is not necessary, my lord, at present in this case, my lord.
Why? Informant
strike out, my lord. That
My lord,
yes, yes.
not my lord, may appear, my lord, but even my lord, his absence, my lord, it can be proceeded, my lord. Not POCTO matter, my lord.
Okay. Yes.
My lord, the FIR space.
Today it is for suspension.
Yes, my lord.
It come under, my lord, that is my lord, hearing column, my lord. So my lord,
appeal may be here.
Appeal may be heard, my lord. Or otherwise, my lord, date may be fixed.
My lord, 6 PW, my lord. Out of 6, here is the 4 PW is very vital. And I have prepared a short argument also, my lord. I think it will be help, my lord. And my lord, though the judgment is very long.
That look at the clock was not because you take a long time. That look at the clock is because we will require a long time.
My lord, I think it will be possible, my lord, because
not I also need some time to go through the my lord TCR, my lord. I am not able to go through entire TCR, my lord, to flag mark, my lord, find the relevant part.
I have prepared also. আপনার তো কপি দিবে এটা একদম very short করেছি এটা তো লগ এটা দিয়েছো এটা দিয়ে
There's already an order to have it listed on 21/4.
My lord, the affair is shortly just I am reading, my lord. Only the affair, shortly I am reading. My lord, the page 15 of my appeal, respectfully beg to state that
Lots of business.
It is. Yes.
Page 15, my lord, 1-5. Affair, my lord, on my appeal. 1-5. Respectfully begs to state that I stay in a rented house at 2 number Madgaria under Nunmati police station on 28/06/2005.
We have read it then. We have read it then.
Yes, madam. Page 15.
We have read the FIR.
Yes, madam.
She had gone to give an examination.
Yes, madam.
Someone told that she has gone in an Indica car with the petitioner who drives the vehicle of some Mr. Kolita. Yes, then?
Yes.
Then what happened?
My lord, thereafter the investigation completed and submitted charge sheet under section 366 IPC. And my lord, charge was framed under section 366A of IPC. And initially, my lord, subsequently, my lord, the charge was altered and he was convicted under section 366 and 375 on, my lord. My lord, here, 6 PW was examined, my lord. I'm reading the PW. One is the, my lord, Alice victim, my lord. Though, my lord, here is handwriting, my lord. I have typed it, my lord. Yes, it will open. The type function. One of the PW1, I'm reading, madam. From the statement of PW. PW1 is the alleged victim, and PW2 is the mother, who is the informant in this case, and 3 is the father, and 4 is the investigating officer, and other 2 also police officer, but they have no importance role because one submitted charge sheet and other just, well, took the charge, but within short time he transferred. Therefore, he could not do nothing. So, my lord, here the vital witness, no independent witness here, the alleged victim and the parents. And, my lord, she initially did not disclose that she was raped when she kept in the house of the alleged appellant. And subsequently, when she came to the court and she deposed that she was raped. And the investigating officer, PW4, also confirmed that, yes, it was not stated before me. And, my lord, so many inconsistency of the PW's, my lord. So, just, my lord, one PW I'm reading, my lord. The PW1, my lord. আসামি সোয়ানচুক চিনুক বসন্তী কৰ্মকাৰ মোৰ মা হয় ঘটনা 2005 চনৰ 2005 চনত মই ক্লাছ 7ত পঢ়ি আছিলোঁ নুনমাটি হাইস্কুলত মই স্কুল গৈ থাকোঁতে আসামী এখন চাৰিচকীয়া গাড়ী লৈ আহি মোক গাড়ীত উঠাই লৈ গৈছিল মোক গোৱালপাৰালৈ নিয়ে আসামীয়ে মোক সিহঁতৰ ঘৰত 4 দিনমান ৰাখে আসামীয়ে মোক বলপূৰ্বকভাৱে ৰেপ কৰিছিল মই মানা কৰা সত্ত্বেও মোক ৰেপ কৰিছিল মাহত পুলিচৰ সহায়ত গোৱালপাৰাৰ পৰা আসামীৰ ঘৰৰ পৰা মোক উদ্ধাৰ কৰে মোক পুলিচে চিকিৎসালয়লৈ প্ৰেৰণ কৰিছিল মোক সোধপোছ কৰিছিল মোৰ জবানবন্দী আদালতত 164 ধাৰাত CRPC লিপিবদ্ধ কৰিছিল সেই সময়ত মোৰ বয়স 13-14 বছৰ আছিল মোৰ জন্মৰ প্ৰমাণপত্ৰ ঘৰত আছে প্ৰয়োজন হলে প্ৰদৰ্শনী অন মোৰ জবানবন্দী প্ৰদৰ্শনী 1 and 2 মোৰ সহি মোৰ জন্মৰ কাগজ আদি মোৰ জন্মৰ 1 4 to 1994 প্ৰদৰ্শনী 2 হৈছে মোৰ জন্মৰ প্ৰমাণপত্ৰ স্কুল সাৰ্টিফিকেট পেজ 1 অৰিজিনাল ইন ক্ৰছ মোৰ জন্মৰ প্ৰমাণপত্ৰ নাই স্কুল সাৰ্টিফিকেট আৰু এডমিট কাৰ্ড আছে বয়সৰ কাগজ প্ৰদৰ্শনী 2 খন মই গছৰত দিয়া নাই মায়ে দিছে যদি মই নাজানো পুলিচে তদন্ত কৰি গোৱালপাৰাৰ পৰা উদ্ধাৰ কৰিছিল মোৰ জবানবন্দী তাৰ পৰা লৈছিল আদালতৰ 164 ধাৰা CRPC জবানবন্দী দিছিল মই 161 ধাৰাৰ জবানবন্দী দিয়াৰ পিছত 164 ধাৰাত CRPC জবানবন্দী দিছিল এইটো সত্য নহয় যে তদন্তকালত পুলিচৰ বিষয়ৰ আগত জবানবন্দী দিওঁতে মোক আসামীয়ে ৰেপ কৰা বুলি কোৱা নাছিল তদন্তকালত এইটো সত্য নহয় যে মই পুলিচ বিষয়ৰ আগত সপিউৰে মোক গোৱালপাৰালৈ গুৱাহাটীৰ পৰা নিয়ে তাতে তাক গোৱালপাৰাত ৰাখে আৰু মোক সপিউৰৰ মাক বাপেকৰ লগত ৰখা বুলি কৈছিল মই প্ৰথমে নুনমাটি স্কুলত ক্লাছ 7ত পঢ়ো মোৰ বদনাম হোৱাৰ পিছত তাত নপঢ়িলো মই শেষত নাৰাংগী বিদ্যালয়ৰ স্কুলত পঢ়িছিলো মোক আসামীয়ে গাড়ীত তুলি নিওঁতে চিয়াৰবাখৰ কৰা নাছিল এইটো সত্য নহয় যে তদন্তকালত পুলিচ বিষয়ৰ আগত মই স্কুললৈ যাওঁতে আসামীয়ে চাৰিচকীয়া বাহনত নিয়াৰ কথা কোৱা নাই যদি মই পুলিচ বিষয়ক ঘটনাৰ সময়ত মোৰ পৰীক্ষাৰ সময়ত ববিতা ডেকাৰ ঘৰলৈ 28/6/2005 তাৰিখে গণিতৰ প্ৰশ্নৰ উত্তৰৰ কথা সুধিবলৈ গৈছিলোঁ তাত 1 ঘণ্টামান থাকো 10 মান বজাত ওলাই আহোঁতে ঘটনা হোৱা বুলি কৈছিলোঁ যদি পাহৰিলোঁ এইটো সত্য নহয় যে পুলিচক ক্লাছ 7ত পঢ়া বুলি কৈছিলোঁ এইটো সত্য নহয় যে আসামী মোৰ লগত দেউতাকৰ ভাল সম্পৰ্ক আৰু মোৰ লগত ভাল আছিল এইটো সত্য নহয় যে তদন্তকালত আসামীয়ে ট্ৰাক চলোৱাৰ কথা, মোৰ দেউতাও ট্ৰাক চলোৱাৰ কথা, আৰু সেই দুয়োজনৰ মাজত ভাল সম্পৰ্ক থকাৰ কথা। মই আসামীক দাদা বুলি মতাৰ কথা আৰু মাজে মাজে আমাৰ ঘৰলৈ অহাৰ কথা তদন্তত পুলিচক বিষয়াক এইটো বুজা নাযায়। এইটো সত্য নহয় যে প্ৰদৰ্শনীটোত ভুৱা আৰু বনাই অনা, এইটো সত্য নহয় যে আসামীৰ লগত আমাৰ ভাল বাবে আমি ফুৰিবলৈ তাৰ ঘৰত গৈছিলোঁ। এইটো সত্য নহয় যে আসামীয়ে মোক ৰেপ কৰা নাই। এইটো সত্য নহয় যে সঁচা কথা উকোৱা বুলি মেডিকেলত কৰিছিলোঁ। এইটো সত্য নহয় যে মা দেউতাই মিছা গোচৰ দিছে আৰু মায়েও দেউতাৰ লগত মিলাই মিছা সাক্ষী দিছে। Now, PW2 is very short. His mother saying that মই গোচৰীয়া, আসামীক চিনিছো, ভুক্তভোগী অনিতা কৰ্মকাৰী মোৰ ছোৱালী হয়। ঘটনাৰ চন আৰু তাৰিখ পাহৰিছো। ভুক্তভোগী ছোৱালী পৰীক্ষা দিবলৈ গৈছিল। আসামীয়ে ৰাস্তাৰ পৰা উঠাই তাইক লৈ গৈছিল মই গম নোপোৱাকৈ। গধূলিলৈ নহাত মই চিন্তিত হৈ স্কুললৈ যাওঁ। ছোৱালী নাপাই নুনমাটি থানাত এজাহাৰ দিওঁ। পুলিচে তদন্ত কৰা ছোৱালী উদ্ধাৰ কৰে গোৱালপাৰাৰ আসামী ঘৰৰ পৰা। আমিও পুলিচৰ লগত গৈছিলোঁ।
Lordship, my senior Mr. R.C. Shakya has to run away.
Run away? No, we have to do it.
Run away madam, due to some urgent family issues. That's why.
You are enjoying an interim protection.
He was eagerly waiting to proceed with this matter, but ultimately, due to some urgency.
There is no interim order, madam.
And besides that, Lordship, it's a urgent matter, so kindly.
Yeah, but there is what happened to that? What do you say? Compromise? Nothing happened.
Compromises, yeah.
Big failure. Try on the 28th or 30.
Lordship, if possible, then can it be fixed on next Tuesday?
Next Tuesday, we are a bit heavy both.
Thursday.
Next week, it is already full because 1st of May is also gone. 1st of May is also gone.
It's a late.
Therefore, cases are being fixed otherwise.
May days.
7th earliest.
7th of May.
Well, but 7th of May, we have fixed a series of petitions. Therefore, we had suggested 12th. 12th or 14th, they may be time to
14, madam. 14.
do and dispose the matter.
14.
Otherwise, getting it listed and then again for another date makes no sense. 14th of May.
Madam.
Request of the Learned Council for the petition for the parties. List again on the 14th of May.